Senator.
Okay, that's fine.
Senator Carson, you should be all set.
Thank you very much, Aaron. Good afternoon, everyone, and welcome. I am Senator Sharon Carson from District 14. Today, we will be holding a meeting of the Senate Judiciary Committee. Before we get started, I'll read through a checklist to ensure that the meeting we are holding is in compliance with the right to know law. Excuse me. As chair of the Judiciary Committee, I find that due to the state of emergency declared by the governor as a result of the COVID-19 pandemic, and in accordance with the governor's emergency order 12 pursuant to executive order 2020-04 and its extensions, this public body is authorized to meet electronically. Please note that there is no physical location to observe and listen contemporaneously to this meeting, which was authorized pursuant to the governor's emergency order. In accordance with the emergency order, I am confirming that 1, we are providing public access to the meeting by telephone with additional access possible by video and other electronic means. We are utilizing Zoom for this electronic meeting. All members of the committee and selective legislative staff have the ability to communicate contemporaneously in this meeting through this platform, and the public has access to contemporaneously watch and/or listen to the meeting on Zoom or YouTube and via phone by following the directions and links provided on the General Court website. 2, we have provided public notice of the necessary information for accessing the meeting in the Senate calendar. 3, we are providing a mechanism for the public to alert the public body during the meeting if there are problems with access. If anyone has a problem, please email remotesenate@leg.state.nh.us or call area code 603-271-6931. 4, in the event the public is unable to access the meeting will be adjourned and rescheduled. 5, please note that all votes taken during this meeting shall be done by roll call vote. And 6, finally, let's start the meeting by taking roll call attendance. When each member states their presence, please also state where they are and if anyone else is in the room with you during the meeting, which is required under the right to know law. I will call the roll. Senator French.
Harold French, Senator, District 7, broadcasting live from the office in Concord. Attorney Sullivan is in the office with me.
Thank you. Senator Whitley.
Good afternoon. This is Senator Becky Whitley. I'm at my house in Hopkinton. I'm alone in the room, but my husband is in the house.
Thank you. Senator Gannon.
Senator Bill Gannon. Behind me, you can't see it, but it's beautifully freshly planted rose bushes. That was my Mother's Day present. I'll share the pictures with you sometime. I'm in Sandown alone in my home office.
Thank you. And Senator Khan.
Good afternoon, Madam Chair. This is Jay Khan in Keene at home. My wife is elsewhere in the house.
Thank you. And again, I'm Senator Carson. I am at my home in Londonderry, and my daughter is in the room with me. Okay, we're going to get started today. We're going to open the public hearing on House Bill 196 and call the prime sponsor, Representative Yakubovich.
Thank you, Madam Chair, members of the committee. My name is Michael Yakubovich. I'm representing District 24 in Merrimack, which is the town of Hooksett. And today, I'm grateful to present House Bill 196. It's a small bill, just a few lines being changed. It adds the exception of trying to warn off an attacker in criminal trespass cases to the statute of criminal threatening. So in our age, in the modern age of peaceful resolution and de-escalation, I believe my bill, which deals with the defensive display of a firearm, is needed to clarify the statute that we have today. It doesn't deal with the use of firearm. This is just a display. People who resort to displaying a firearm to warn of attackers or somebody trespassing criminally deserve the protection of the state, deserve to know that they will not be charged, and that their actions will lead to de-escalation, to lives being saved, and to everybody walking away peacefully.
Great. Okay.
Yes, thank you.
Thank you very much for your testimony, Representative. Are there any questions? Senator Gannon has a question.
Thank you, Representative, for taking my question. Was your intent, is it sort of, there was a famous scene last year when it was a gated community, people had broken by the gate and they were passing by a house, a husband and wife were displaying weaponry in defense of their house, in their opinion. Is that what you're trying to do? Something like that? Can you paint the picture better than that, or is that what I'm looking at?
Thank you, Senator, for the question. That actually did cross my mind. The whole year, the previous year has been different for everybody, each one of us. And yes, I'm aware of that case. I believe that was St. Louis. And there were people passing through the yard or through the property. And the homeowners, startled, only wanted to do nothing with that crowd. That's why they were trying to show them, well, show them away, but they got charged for it and they got prosecuted and believe they got pardoned. So that's just a waste of time, of everybody's time and money for the state to go after people who are just having dinner, trying to enjoy their evening. So they should be able to warn of the attackers and go back home.
Quick follow-up,
Attackers or
Madam
trespassers.
Chair.
Thank you.
Yes, Senator Gannon.
And so is that's encompassing, wait, is there further intent beyond that? Or is that the type of situation you're trying to rectify? Or is there more to it?
In Manchester, for example, in the summer, thank you, Senator, they were demonstrations that were guided by the police through the streets peacefully. But among those crowds, there were a few hooligans who attempted to approach stores and delis and coffee shops on South Willow and Elm Street. And in those cases, again, they were peaceful property owners, peaceful store owners that stood by the doors and told the hooligans to go away, mind their own business. They had firearms. So I believe that's the proper use of a firearm, a defensive display. That's whom we're trying to dissuade here.
Okay, thank you, Representative.
Senator French?
Thank you, Madam Chair, and thank you, Representative. When this reads, a person responds to a person criminally trespassing, is that, it doesn't state whether it's on their their property or a property of others, does it?
It does not. Thank you, Senator, for the question. It does not. But criminal trespass is a statute. It's well defined what it entails. It's 635:2.
Mm-hmm.
So everything that falls under there.
So, but a store owner standing in his business doorway holding a gun when protesters are walking by on the streets, they are not criminally trespassing, correct?
If they're not on the property, if they do not have an intent, I'm sorry, let me go to the bill here, to cause property damage, seriously bodily injury or death, that's part of my bill.
Right.
Then, yeah, people walking by, yeah, not trespassing, if they do not have
Okay.
that intent.
Okay. Great, thanks.
Thank you.
Are there any further questions? Representative, I have a question. When you talk about display, what do you mean when you're talking about display? Are you talking about someone just perhaps if they have a rifle and they have it slung over their shoulders where the rifle is in front of them? Or are you talking about someone actually pointing a weapon at another person?
Thank you, Madam Chair, for the question. So display, since it's not defined in statute, I mean, common English words which are not defined in statutes, for those we go to the dictionary to find out what they mean, which I do very often. So display here in my definition from the dictionary, it says exhibit where it's visible with the clear intent. So for me, displaying is to warn somebody off, which is a deliberate action. You display your firearm, you make it visible to the person.
Okay. Okay, thank you very much, Representative. Senator Gannon has another question.
Yes, thank you, Madam Chair. Following up the chair's question a little bit, would that display, are you talking, including pointing a gun at someone, or is it going that far, or is it just holding it? Would pointing the weapon be a more overt act beyond? And is that included in what you were looking for here?
It is not included in the language of the bill.
Okay. That's all I need to know. Thank you.
Yeah, thank you.
Are there any further questions for the representative? Okay, seeing none. Thank you very much, Representative.
Thank you.
Next, we're going to go to Aaron Jacina.
Yes, thank you. Good afternoon, Madam Chair, members of the committee. My name is Erin Jacina, and I direct the Domestic Violence Advocacy Project of New Hampshire Legal Assistance. We represent low-income victims and survivors of domestic violence, sexual assault, and stalking in their protective order cases, as well as in high lethality divorce and parenting cases. I'm here today to testify in opposition of House Bill 196. House Bill 196, if passed, will give abusers yet another tool to continue abusing their victim. It creates an exception where someone can display a gun, possibly fire that gun, and then claim that they did so in the name of protecting themselves against criminal trespassing. So I was trying to think of a scenario that would help explain this bill a bit more and why it could go horribly wrong if passed. So imagine two separated parents. They have an arrangement to exchange their child at 4 p.m. on a Friday. The exchange is scheduled to happen at Dad's house. Dad has a history of violence against Mom. That morning, Dad gets very angry with Mom because he found out she has a new boyfriend. He's swearing at her, he's calling her ugly names. He tells her that he doesn't want to see her face ever again. At the same time, he's demanding that he gets their daughter at 4 p.m. So Mom shows up at the house at 4 p.m. Dad comes to the door and he becomes irate. He's screaming at Mom that he told her he never wanted to see her face again. She shouldn't be on his property. Next, he pulls a gun to warn her off in front of their daughter. He's displaying his weapon. So Mom starts shouting for him to put the gun away. She tries to talk him down. It escalates to the point where he fires the weapon. Mom has been killed in front of their daughter. What is to prevent an abuser from luring his victim to his home only to say that she was trespassing, and to defend against that trespass, he had to display his firearm and then discharge it? I'm asking this committee to vote inexpedient to legislate on House Bill 196. Please do not give abusers a get out of jail free card. Thank you, and I'm happy to take any questions.
Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none, thank you.
Thank you.
Next, we're going to go to Pamela Kiley.
Hi, good afternoon. Can you hear me okay?
Yes, we can.
Sorry, good afternoon. Can you hear me okay?
Yes, we can.
Okay, I apologize. My internet connection might break out, and if that's the case, I'll call in.
That's okay.
Thank you so much. For the record, my name is Pamela Kylig, and I'm the Public Policy Specialist at the New Hampshire Coalition Against Domestic and Sexual Violence. I'm here in opposition of HB 196, which would add trespass as an exception to the charge of criminal threatening, something that could be extremely dangerous for people experiencing domestic violence and abuse. Thank you so much for this opportunity. As you just heard, if passed, this legislation will greatly tip power and control into the hands of the abuser and place domestic violence victims at severe risk. While we absolutely recognize the right of New Hampshire citizens to own and have access to guns, I want to briefly highlight how firearms can be used by abusers in domestic violence cases. Domestic violence is the deadliest crime in our state, and it is essential that we are not giving abusers more opportunities to intimidate, threaten, or hold power over victims. Many abusive partners use firearms to control and even terrorize their victims in non-fatal domestic violence cases, whether it be an abuser threatening to shoot a victim with or without displaying the firearm, intimidating the victim with the weapon, or simply having the gun present. This could be heightened if the abuser has previously threatened to shoot the victim, making the mere presence of a gun an alarming sight. Firearms do not have to be fired in order to instill fear, and the absence of physical injuries should not undermine the psychological harm that victims experience, which can have long-term impacts on their mental health, including post-traumatic stress disorder. Statistics from the National Violence Against Women survey suggest that 3.5% of women in the US have been threatened with a gun by an intimate partner, and this equates to roughly 4.5 million people. It is our understanding that this bill would allow a person to threaten anyone who enters or remains in any place without license to do so with a firearm. And in other words, this bill makes it so a person can display a firearm in response to criminal trespassing without violating the law. If passed, this bill would make it much harder to prove criminal threatening and create a defense for those breaking the law. This could be really dangerous in domestic violence incidents where legally individuals could pull a gun on someone who doesn't immediately leave when they are asked. This could result in extremely negative consequences in domestic violence cases because the victim would not be able to charge an abuser with criminal threatening if the abuser asked them to leave. I also just want to draw your attention to 2 additional statutes that already provide these protections in defense of property that does not in any way provide opportunities for abusers to further abuse their victims. RSA 627.4, the physical force in defense of a person, and RSA 635.1, New Hampshire's burglary statute. Both statutes already have these protections in place and are far better defined than these amendments, as well as the use of the burglary statute would not intersect with domestic violence in a negative way because it would be really difficult for that case to be made in a domestic violence incident. In conclusion, I strongly urge the committee to consider voting ITL on this bill and ensure that abusers are not granted additional opportunities to threaten and control victims of domestic and sexual violence, and to make sure that we maintain the current balance we have between an individual's ability to defend their property without wielding too much power that would prevent anyone from being held accountable. Thank you so much for your time, and I'd be happy to answer questions.
Thank you very much for your testimony. Are there any questions for Ms. Kiley? Okay, seeing none. Thank you very much. Okay, next we're going to go to Tracy Hahn Burkett.
Can you hear me?
We sure can.
Great.
Good afternoon.
I'm Tracy Hahn Burkett, and I'm the leader of the Gun Violence Prevention Working Group of the Kent Street Coalition. Thank you for giving me the opportunity to speak with you today. First, I'd just like to associate myself with the remarks of the domestic violence advocates who came before, but I won't go into that because they've already done that very well. I'd like to add to that, though, that I'm testifying in opposition to HB 196 today because I believe that by expanding the exception for criminal threatening to someone who displays a firearm because she believes a person who is trespassing might cause even a minimal amount of property damage, what this does is that it encourages a cavalier and disproportionate response that can then unnecessarily escalate into a dangerous or even deadly situation. Now, on a basic level, I think we can all agree that under RSA 635.2, a person is trespassing if he's on someone's property, and then if he's asked to leave, he doesn't do that. And so to imagine a scenario, maybe he's a delivery driver and he's trying to figure out where to go next. Maybe she's a canvasser in New Hampshire's longstanding and enthusiastical political tradition. And maybe, she makes one last effort to convince a property owner of her position. Maybe she shouldn't be doing that, but that's what she does. You can think of a lot of scenarios. So does that does someone in either of those scenarios, either the delivery driver or the canvasser, deserve to be confronted with a gun? Isn't that a disproportionate response? And lest you think I'm just exaggerating, I do know canvassers who have faced the barrel of a gun for canvassing. And I can't for the life of me think why New Hampshire law should find that acceptable. HB 196 would make it easier for a person displaying a firearm in response to someone in this type of situation to be excused by saying, I believe they were going to damage my property, so I took out my gun. And anything might qualify for that response here because, you know, there's no dollar limit floor. You know, backing over a just seeded lawn, stepping on a flower bed, negligently disturbing wet paint. Are these things annoying? Sure they are, yes. But they don't warrant someone being threatened with a gun. So for these reasons, I would urge you to vote to ITL this bill.
Thank you very much for your testimony. Are there any questions from the committee? Okay, thank you very much for your testimony this afternoon. Okay, next we have Leonard Witt.
Can you hear me now?
We sure can.
Okay, cool. So as it turns out, my testimony is a little similar to the previous person who just spoke. My name is Leonard Witt. I live in Sandwich, New Hampshire, and I oppose HB 196. I'm active in New Hampshire politics, and each of you as politicians know campaign door knocking is a long-held tradition in our democracy. Yet I know personally one woman here in Carroll County, out of fear, no longer does so. At one house, she explained her mission. The owner pulled a gun and told her to get off his property. It's a true story, which I can verify. It's not a hypothetical. That person with the gun should have been charged with interfering with free election processes, which are protected by law and tradition. Now, this wantonly dangerous bill would provide a new legal argument that gives that same armed and dangerous person a new legal justification to pull a gun with the hidden intent to threaten the life of each of your volunteer campaign workers and threatens our entire election process. Please, for the sake of your campaign workers and all campaign workers across the state, vote this bill ITL. Thank you.
Thank you very much for your testimony this afternoon, Mr. Witt. Are there any questions from the committee? Okay, thank you very much. And next we have Joe Hannon.
Good afternoon, Madam Chairman and members of the committee. My name is Joe Hannon. I'm the Vice President for Gun Owners of New Hampshire, and I'm testifying in support of this bill. It is a very simple change that is being added. It is perfectly legal to be on one's own property and possess a firearm and even display it. If someone comes to their property to criminal trespass, it doesn't, like the sponsor said, it doesn't give them a right to point the gun at the person or even fire a gun. Just the mere display of a gun to dissuade someone from committing criminal trespass or is already in the statutes committing severe bodily injury or attempted to hurt, to kill someone. It was brought up that domestic violence situations would be excused under this law, and I strongly disagree. If someone has a domestic violence restraining order for a history of domestic violence or abuse, they're not allowed to possess a firearm. So this would not give that person in any way the means to excuse that kind of behavior. If a mother or even a husband has a restraining order against a spouse for domestic abuse, this would give that person the means to defend themselves and display the firearm to dissuade a potentially dangerous situation and in turn prevent something from happening in the future. The goal is not to increase violence, but to prevent it. So I strongly urge you to pass this bill. It is a very simple bill, and I'd be happy to take any questions.
Okay, thank you very much, Mr. Hannon. Are there any questions from the committee? Okay, first Senator Gannon. then Senator French.
Thank you, Madam Chair. Hello, Representative Hannan. How you doing today?
I'm wonderful. I'm on vacation.
Oh, lucky for you. I'm jealous. Don't go there. So just help me understand the little bill a little bit differently than the people before you who testified. All seem to be saying like it was the mere presence that was allowing, they were on the property. I see it a little differently in the bill. I see the likely to cause property damage, seriously bodily injury, death to a person or another. I see those as a step before you could. They didn't have that step, the last 2 or 3 people who testified. Am I reading this correctly that it has to have those other elements?
Absolutely.
Property
It's
damage.
just someone walking past the property it's not included. Someone just even on the property that's not posted is not included. They have to be told that they are criminally trespassing before it even becomes criminal trespass. And even then they must not leave for it to be criminal trespassing. If someone's on the property, you say, hey, get off my lawn, and they leave, there is no criminal trespassing and they would not be excused by this bill.
Can I follow up, Madam Chair?
Yes, please.
So again, I see it, not only do you have to not leave, you'd have to do some overt act that's going to cause the person to think that you're going to damage their property. You're going to cause them injury. You're going to have to do something more than just, even if you didn't leave, I don't think they could display the gun. Is that correct?
It would have to be, you're right. It would have to be criminal trespassing, which would involve some kind of property damage.
Okay, thank you.
Okay, Senator French, you have a
Thank you,
question?
Madam. Yep. Thank you, Madam Chair, and thank you, Representative. Could you tell me the difference between bearing a firearm and displaying a firearm?
Well, there's really no difference in New Hampshire law. Display, like the sponsor said, would just follow the dictionary's definition, meaning just to show it. It does not include pointing or even firing the weapon. But it would also, in some states, it was brought up in the House hearings that, it's brandishing. Well, brandishing is a specific language that's used in certain state laws that is not included in this bill whatsoever. So it's really not anything. It's not a significant change. It's basically, you could be just sitting on your porch, cleaning your firearm or holding it. And if someone comes on your property and says, oh, they displayed a firearm at me, well, this would give that person protection because they're on their own property. They'd have to be, actually threatening to shoot. If they pointed a gun and said, I'm going to kill you if you don't leave, that's actually different than displaying a firearm.
So follow up.
Yes, please.
So this extends the reasons for doing it to protect your property, correct?
Yes.
So why is it necessary?
It's necessary for the instances where people are charged just for possessing a firearm on their own property. And the mere display of a firearm should not be used to punish someone who is on their property and legally allowed to have a firearm on their property and display it.
I mean, why is it necessary when the New Hampshire Constitution, Part 1, Article 2A, and the bearing of arms already provides for this?
It does. This just codifies it in statute because the state constitution does say we have the right to defend ourselves, our property, and the state. But this just gives it specific language in an RSA.
And the Constitution isn't good enough?
You'd think it would be.
Okay. Thanks, Joe.
You're welcome, Senator. Thank you.
Are there any further questions for Mr. Hammond? Okay, seeing none, thank you very much.
Thank you all.
Okay, Margaret, that's all who I have who has signed up to speak. Is there folks in the waiting room who would like to speak?
Yes, we have 2 hands, Daniel Eitz and Zandra Rice Hawkins.
Okay, why don't we go to Sandra Rice Hawkins?
Good afternoon. This is Xander Rice Hawkins. I'm the director of Gun Sense New Hampshire, a project of Granite State Progress. I'd like to echo the testimony of some of the previous speakers that this bill is not a bill that is appropriate for New Hampshire. It has a lot of unintended consequences and could provide dangerous situations for, as was mentioned, delivery truck drivers, canvassers, Girl Scout troops approaching a home. And I do want to draw your attention, their question just came up with a previous speaker about the definition of criminal trespass and whether or not some kind of warning, verbal warning or other activity has to take place in advance of House Bill 196 being in effect. If you look at the definition of criminal trespass, RSA 635-2, it says a person's guilty of criminal trespass if they know that they are not licensed or privileged to do so, enters or remains in any place. It then goes on to talk about what the definitions would be to qualify for a misdemeanor, but it does not actually say that you have to have any kind of warning or understanding about that. So somebody coming up your driveway doesn't necessarily have your permission, right, to be there. But as a society, again, canvassers, Girl Scout troops, the kids in my neighborhood to come to sell me magazine subscriptions to fund their public schools. Those are all times where, reasonable people would accept that somebody may come up to your door. That unfortunately is not how everyone understands that. So I do think it's really important to go back to what the sponsor of this bill said, and what their intention was with filing it. It is not to have any kind of reasonable defense, but to really take this to the extreme. And I think that when somebody gives that information to us, we should take it seriously and listen to what they're saying. So I would really encourage this committee to look closely at the RSAs listed here, because I think it is different than one of the previous speakers interpreted. And I'd be happy to take any questions.
Thank you very much for your testimony. Senator Gannon has a question.
Thanks for taking my question. Again, I'm only asking you the question so I better understand what the person put in their bill here. So after you have someone on the property who wasn't invited, that's fine. I don't see the right to take out the gun then. But when it's in the bill here, it says after they've criminally trespassed, when they wouldn't leave, still not able to take out a gun. But you'd have only at the point where they're likely to cause property damage, bodily injury, or death to the person. So they'd have to be in fear of someone, like a Girl Scout you wouldn't be in fear of. So you'd have no reasonable, or even the guy canvassing, you'd have no reason to take out a gun because they're not threatening you. They're not going to damage your property. I wouldn't think those cases would qualify for the person to bring out a weapon. Am I misunderstanding it?
No, I really appreciate this question, because I think that is the heart of our concerns about this bill. The language as it's written really gives a really broad license to intimidate, threaten, harass, coerce, as you heard in the situations of domestic violence cases or potential domestic violence cases. And if you look at the language, it says, which would be considered by a reasonable person as likely to cause property damage. And I really want to draw your attention to that line, because it's very similar to what we saw with House Bill 197, the Stand Your Ground legislation around a perceived threat. So we really need to be cautious. What I perceive as a threat may be different than what you perceive as a threat. And, implicit biases come into play there. So if I see a Black or brown person walking up to canvass my house or to deliver a box, for me as an individual, that's not going to raise any alarms for me. For somebody else, or maybe thinking back to, as the sponsor said, that situation in Missouri with the couple who stood on their lawn with their firearms, that is a very different application of what this bill would do. So we would really discourage the Senate Judiciary Committee from advancing this.
Thank you, ma'am.
Thank you.
Okay, are there any further questions for Ms. Rice Hawkins? Okay, seeing none, thank you very much for your testimony. And we have one more speaker, and that is Dan Itza.
Thank you, Madam Chairman, members of the committee. For the record, I am former Representative Dan Itza. I am speaking on behalf of New Hampshire Firearms Coalition, and I do rise in support of this legislation. You don't have to reach back to last summer or outside of New Hampshire to know why this bill is necessary. There was a case, I don't know, I think 10 years ago, Senator Carson may remember this, where a gentleman had a trespasser on his property, and he simply held his rifle, I believe it was, or maybe a shotgun, at low ready. and the police charged him with brandishing. And that's the type of situation that this is intended to stop. That if you simply make aware, you display, whether you show someone you have a sidearm and a holster, or you hold a long gun at low ready and you say, I've asked you to leave, now leave. That's what this is intended to protect. I don't think you can get there under a domestic violence situation. If someone has a court order to exchange, to transfer custody of a child, I don't see how they could be reasonably construed as criminal trespassing, especially if there's some record that they were requested to appear at a particular time to effect that exchange. We already have very strong domestic violence laws that would enable somebody so feared to deprive the abuser of their firearms. So I don't see that as a great threat. Not that such things couldn't happen, but we don't write the law for every particular possible situation. You can imagine something going wrong with almost anything you might legislate. You need to keep the eye on the big picture, and the big picture is people in New Hampshire have been arrested, gone to jail for simply displaying a firearm after they've asked somebody to leave their property.
Okay, thank you very much for your testimony. Are there any questions from the committee? Senator French.
Thank you, Madam Chair. And thank you, Dan. Wasn't that Bird who that happened to?
I don't know that it was Mr. Bird. I think there was another situation prior to Mr. Bird, but Mr. Bird is another good example of somebody who simply displayed a firearm to ward off a situation. And that's what we're trying to correct, where somebody attempts to de-escalate a situation by showing that they are prepared to deal with it.
I do recall Bird going to jail, correct?
Yes, that is correct.
And the Article 2 of the Constitution did not protect him from that, correct? Obviously, he went to jail.
That is correct. You have to remember the Constitution is a set of principles and is put into action by the statutes. And that's the job of legislators, is to parse those statutes.
Got you. Okay, thanks, Dan.
Okay, are there any further questions for Mr. Itzy? Okay, seeing none, thank you very much. Okay, do we have anyone else, Margaret?
We do have Leonard Witt with his hand up again.
Okay, why don't we put Mr. Witt through for the last time?
Yeah, I just, as a door knocker, the very fact that people have now another justification to point a gun at me or any other campaign worker is going to prevent a lot of people from going out and knocking on doors and practicing the free right that we have. And just ask your own campaign workers how they feel about it. Thank you.
Okay. Okay, thank you very much for your testimony. Are there any further questions? Okay, seeing none, thank you very much. Margaret, anyone else?
There are no other hands raised.
Okay, I am going to go ahead and close the public hearing on House Bill 196. Okay, we're going to just keep moving right along. I am going to open the public hearing on House Bill 195. And let's see, okay. I'm sorry, I'm just trying to get the bill here. And I'm going to call the prime sponsor, Representative Yabovovich again.
Thank you, Madam Chair, members of the committee. Glad to be back to talk about this bill. It's quite similar. Oh, my name is Michael Yakubovich. I am from Merrimack 24, District 24, which is the town of Hooksett. It is quite similar to the previous bill we just heard and discussed. Again, a few line changes in the law. Here we're trying to clarify what's enshrined in the Constitution, just like Senator French mentioned, the right to bear arms from the New Hampshire Constitution. We're changing the statute where it's not clear enough. Right here. RSA 631:3, by inserting a paragraph that displaying a firearm shall not constitute reckless conduct under this section. That's it. And as myself, I'm a door knocker for my own campaign. I've walked the whole town. I have friends. And if somebody wishes to show me their firearm, I will actually appreciate it very much, because I'd rather be shown a firearm than be shot with it. So a warning is plenty for me. So again, very similar bill to the previous one, a different portion of the statute. That's why it's a different bill. Thank you. I'll take any questions.
Thank you very much for your testimony. Are there any questions for Representative Yakovich? Okay, seeing none, thank you very much for your testimony. Next, we're going to go to Erin Jacina.
Thank you, Madam Chair and members of the committee. Again, my name is Erin Jacina, and I direct the Domestic Violence Advocacy Project of New Hampshire Legal Assistance. I'm here today to testify in opposition of House Bill 195. So I'm not sure if anyone had a chance to look at the news over the weekend, but on Saturday in Times Square, there was a shooting. Witnesses reported that 2 to 4 males were involved in a dispute, and that at least one person pulled or displayed a gun. 3 innocent bystanders were shot as a result of this display, including a 4-year-old girl. This is exactly the kind of scenario we are inviting if House Bill 195 is passed. This is not a big city issue. With gun violence on the rise, a free pass that this bill creates will bring more gun deaths to New Hampshire. In terms of domestic violence, as you know, it can take many forms. It can appear as black and purple bruises, or it can be a more silent killer and take shape through intimidation and veiled threats. Words and actions that seem harmless to anyone else hearing them might signal death for a victim. Imagine if you got a phone call at work from your spouse saying, "You better pick up eggs on your way home." What would you think? You would probably think you're out of eggs. So for a victim, that may be a signal or a trigger. That may be code for "you better come home now or I'm going to break your arm." The same signal or trigger may exist for an abuser displaying a firearm to his victim. What seems harmless to you on the surface is in fact a means to exert control over a victim and instill fear. Sitting down at the kitchen table every night and methodically taking apart and cleaning your gun while making your victim watch is placing that person in danger of serious bodily injury. Because if she does not do what he says, he will make good on his threat and use that gun against her. Leaving or displaying that same gun on the bedside table every night is a clear message to that victim that you aren't going anywhere, so don't even try. I'm asking this committee to vote inexpedient to legislate on House Bill 195. Please do not give abusers an exception to get away with violence. Thank you, and I'm happy to take any questions.
Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none, thank you.
Thank you.
Next, we're going to go to Pamela Kylig.
Good afternoon, Madam Chair and members of the committee. Can you hear me okay?
Yes, we can.
Awesome. Again, for the record, my name is Pamela Kylig, and I'm the Public Policy Specialist at the New Hampshire Coalition Against Domestic and Sexual Violence. I'm here in opposition to HB 195, which would add display of a firearm as an exception to reckless conduct. Thank you again for this opportunity. I will keep my testimony brief, as I have already addressed several concerns during my previous testimony on HB 196. Similar to that bill, this legislation would greatly impact victims of domestic and sexual violence and place them at a severe risk. It is vital that we are not giving abusers more opportunities to intimidate, threaten, or hold power over victims. Adding display of a firearm as an exception to reckless conduct would allow an abuser to use a firearm as a tool to further coerce and intimidate their victims, as you've already heard today. An abuser displaying their gun is an intentional act aimed at sending a threatening message and cannot be interpreted as neutral or passive. Finally, a huge component of how we understand the term reckless conduct is based on whether a person's behavior places or may place another in danger of serious bodily injury. This could give abusers leverage and power to legally threaten victims without it being considered a form of coercion or abuse. While the bill does not go as far as to protect those who point a gun at an unarmed person and threatens to shoot them, it does make it okay to intentionally display your gun as a warning sign. This is unnecessary and potentially dangerous change to our current statute and absolutely should not pass. I really strongly urge the committee to vote ITL on this bill, and I'd be happy to answer any questions if anything needs to be clarified. Thank you so much.
Thank you very much for your testimony this afternoon. Are there any questions for the committee? Okay, seeing none, thank you. Next, we're going to go to Lois Cody.
Thank you, Madam Chair and committee, for the opportunity to testify. My name is Lois Cody. I am a volunteer with the New Hampshire chapter of Moms Demand Action for Gun Sense in America and a resident of Manchester. I am submitting written testimony in opposition to House Bill 195, as this bill is a dangerous invitation to draw and brandish firearms recklessly, including for the purpose of intimidation, without fear of criminal consequences. This is not how responsible gun owners behave, and it should not be allowed or encouraged in the Granite State. The bill plainly states that displaying a firearm can never be deemed reckless conduct under New Hampshire law. Our law defines reckless conduct as, quote, conduct which places or may place another in danger of serious bodily injury. There are numerous examples in which drawing a firearm may place another in danger of serious bodily injury. Imagine a traffic dispute in which one party draws a gun, prompting the other to veer off the road, or brandishing a firearm in a crowd, causing panic and possible injury, or drawing a firearm while intoxicated. The very thought that drawing and displaying a deadly weapon cannot, by definition, be considered a reckless act just does not line up. The message that this policy gives to New Hampshire gun owners is that they have no duty to others to safely and responsibly manage their firearms, and that drawing their gun, no matter the context in which they do so, cannot ever result in a criminal charge of reckless conduct. Finally, our New Hampshire Constitution, Part 2, Article 5, describes the responsibility of the legislature as, quote, establishing wholesome and reasonable laws that are not repugnant or contrary to this Constitution. And further, Article 1 of our Bill of Rights states that this Constitution is, quote, instituted for the general good. There is no way House Bill 195 meets these criteria. I urge you to oppose House Bill 195. Thank you, Madam Chair and committee, for your time.
Thank you very much for your testimony this afternoon. Are there any questions from the committee? Okay, seeing none, thank you. Next, we're going to move to Julie Smiley.
Julie, if you could virtually raise your hand. I do not see Julie.
Okay, let's move on to Valerie Fagan.
Can you hear me?
Yes, we can.
Great. Good afternoon, Madam Chair Carson and members of the committee. My name is Valerie Fagan, and I am a volunteer with the New Hampshire chapter of Moms Demand Action for Gun Sense in America and a resident of Rye, New Hampshire. Research shows that visible guns have been found. Oh, I'm here today to oppose House Bill 155. Research shows that visible guns have been found to make people more aggressive. Therefore, displaying a gun makes it more likely that disagreements will turn into violent conflicts. Holding a gun impacts various cognitive processes. Research has found a gun embodiment effect in which holding a gun in comparison to holding another object impacts, among other things, a person's attention's priorities and ability to judge if someone is armed or holding a neutral object. A gun does not need to be fired to inflict fear and abuse. Approximately 4.5 million American women alive today have been threatened with a gun by an intimate partner. One study of domestic violence and cohesive control found that women who had been threatened with a gun or feared that their partner would use one against them had more severe psychological symptoms than women who had endured other types of abuse, such as psychological or physical threats. So please, I urge you to oppose House Bill 195, and thank you so much for your time today.
Thank you very much for your testimony. Are there any questions for Ms. Fagan? Okay, seeing none, thank you very much. Next, we're going to Barbara Prian. Good afternoon.
I had actually signed up for 307 and inadvertently signed up for this. So I had written and asked that my name be taken off for this hearing and only put on for 307. Sorry.
Okay, we'll hear from you on House Bill 307.
All right, thank you.
Thank you. Bye-bye. Okay, next we're going to go to Sadie Zavgren.
Sadie, if you could virtually raise your hand. I do not see Zadie.
Okay, let's go to Joe Hannon.
Good afternoon, Madam Chairwoman, members of the committee, long time no see. My name is Joe Hannon, and I'm the Vice President for Gun Owners of New Hampshire. I'm testifying in support of this bill. This is also something that is being overblown, I think, greatly. The mere display of a firearm is perfectly legal in New Hampshire. We have been an open carry state, and since concealed carry was passed without a permit, you also don't need a permit to carry one concealed. The mere display of a firearm is not giving someone license to threaten, to point a gun, or even fire a gun at someone. It's just a mere display. So if someone has a gun, is walking to their hunting spot or their gun club or wherever they may be going in New Hampshire legally with a rifle over their shoulder, a pistol in a holster, or even carrying it, does not constitute a crime in New Hampshire. But people may be charged with reckless conduct by certain individuals if they decide to just make that stretch. And that's exactly what it is. It's a stretch of the law. The reckless conduct statute is specifically for conduct which is reckless. Someone with disregard or possibly putting someone else's life in danger. Just because something is on a sling or being held does not mean it is reckless unless they're pointing it at someone or actually threatening them. In domestic violence situations, again, this does not apply to that. If someone has a history of domestic violence or abuse, they can easily get an order which would prohibit them from even possessing a firearm. If someone is threatening someone in a domestic violence situation, there are still statutes which would allow that person to be charged for that and under domestic violence statute. So this is basically just protecting people who are already exercising their rights in New Hampshire. And it's making it very clear to law enforcement and anyone who would decide to add a charge needlessly to just displaying a firearm. I'd be happy to take any questions, and thank you very much.
Okay, thank you very much for your testimony. Are there any questions from the committee? Senator Gannon has a question.
Hi, Representative Hannan. So I think the word that display would be displaying. And so I think for me, like I saw a difference between, I certainly think all these women who are domestic assault victims, their husband has the gun on the side of the table, or someone in a car who's brandishing the weapon. I see those as sort of an assault because you're putting another in fear or apprehension of imminent bodily harm with a reasonable person standard. I see a big difference between that and what you're saying. Like if it's just a visible thing that's on your holster or something behind your suit coat, I don't see that as offensive, but I do see the examples everyone's been giving to me are very different. They're more of an assault, right? Putting someone in fear or apprehension, putting that wife because she knows you have a pattern, you're doing it for those reasons. I see the word displaying something totally different.
I agree. There was one example that I thought was a little odd, was someone cleaning their firearms would be considered a threat in their own home, which is, you know, it would have to be someone doing that and saying, you know, I'm going to shoot you if I don't, you know, whatever, if you don't get the eggs. But, you know, that's not what's happening. People are going to clean their firearms. If they have a history of domestic violence, they will be able to get an order against that person. So it doesn't apply in those situations. I agree.
No, on
follow
up. Yeah, thank you, Madam Chair. I do see she was getting like a pattern of behavior that you're using it as a threat to the wife. I understand that would be,
yeah,
if you every night cleaning it so she's scared of you. Totally different than if you're down in the basement
right.
once you're cleaning your gun.
That's
okay,
a pattern of behavior. That's a pattern of behavior that could be used to charge someone with domestic violence.
Thank you, Mr. Hannan.
Thank you.
Senator Khan.
Thank you, Madam Chair. So, you know, the word reckless is used twice in statute 631(3). And one of those times is upon proof that the victim and defendant were intimate partners or family or household members, the conviction under this section shall be recorded as reckless conduct, domestic violence. And this bill is aiming to say, well, it's not reckless. It's simply display. So, honorable.
Whatever.
Yeah, Joe. It does seem to cancel out what would be I mean, why would somebody display a firearm before a family member without it being threatening?
I mean, that section would still be part of the RSA. That would not be removed. There is, if someone's making a reckless display, that's certainly different than the mere display. You know, if, for example, I was a Cub Scout leader and I was showing the Cub Scouts the difference between firearms that are real and ones that might look, or toy guns that might look real, and how to tell the difference. You know, I was displaying that. Am I being reckless? Absolutely not. So, you know, that's just one example.
Follow up.
Follow up.
Thank you, Madam Chair. Thank you, and Mr. Hannan. But this is not about displaying it for education purposes or to a Cub Scout unit or anything else. This is displaying it before a family or household member or intimate partner. Sorry to keep to push on it, but I'm sorry, the example didn't address the part of the statute that specifically points out what is considered reckless.
I mean, it's not illegal to show someone a firearm in your home unless you're doing it in a threatening manner and being actually reckless with it. You're pointing it or verbally threatening or even insinuating a threat. But just the mere presence of showing a firearm in your own home is not currently against the law. This is mostly to protect people who may be out on the street or in a public place displaying a firearm. Displaying is to make it visible to the public. And, you know, you're not really displaying anything in your own home. It's your home. You can do whatever you want currently. So we're not adding any special exceptions to someone being in their home.
Thank you for taking my questions.
Thank you.
Senator Whitley?
Thank you, Madam Chair, and thank you for taking my question. So I just want to clarify something that you said. You had indicated that it was easy to get a protective order if this type of treatment was happening. Is that what you meant to say?
Did I say easy? I don't know if I don't remember if I said it was easy or not, but I said they can. They're capable. But as far as reckless, it's the definition is it's utterly unconcerned about the consequences of some action without caution and being careless. So there's a difference between just showing something, displaying it, and being reckless with an object, whether it's a firearm, a baseball bat, whatever.
Follow up if I may? Thank you, Madam Chair. But you do understand that in a domestic violence situation, there is a balance of power. And so it is not always just the case that if there is this type of behavior that was these examples that were given, it's not that easy for a person to just go and get a protective order and protect themselves that way. Isn't that correct?
I don't imagine it would be, but they are able to if they meet certain criteria according to the law.
Follow up? My question is, don't you understand that there's a balance of power that those folks don't often feel like they are safe enough to be able to do that? Isn't that correct?
Well, thank you for telling me what I believe. I believe that I said that I do recognize there is a balance of power, and that's not an excuse for the current laws, which allow people to do certain things. But being reckless or threatening is not something that is being allowed in the law. I understand some people may see this as a gray area, but it is very black and white when it comes to the mere display. If someone's threatening or making any kind of threats, they should pursue charges and get the criminal protection order, which I understand may not be easy to do, but they are able to do it.
Okay. Are there any further questions for Mr. Hannan? Okay, seeing none, thank you very much. Margaret, it looks like we have 4 people in the waiting room who would like to speak.
That is
Okay,
correct.
why don't we go to the first one?
All right, Representative Horgan.
Oh, good afternoon. My name is Representative Timothy Horgan. I represent Stratford County District 6, the towns of Durham and Madbury. So I agree with everything the other opponents of the bill said about this. So we'll just add the way it's written doesn't make a whole lot of sense, even if because a deadly weapon is specifically defined as a gun, a knife, or I think other instruments. Let's see if I got the exact thing here. Any firearm, knife, or other substantive thing which in manner is used, intended to be used, or threatened to be used, is known to be capable of producing death or serious bodily injury. And this bill doesn't cover that RSA, but it does add a thing to RSA 631, which says if you use a deadly weapon as defined, which seems like a reasonable definition, you can be subject to Class B felony. And then he's carving out a special exception for firearms. And first of all, I'm not sure how useful that's going to be even to defendants, because he's merely condoning the display of a firearm. So there's like there's a line between what's simply wearing a firearm and what's threatening it. And certainly in many situations, merely displaying the gun is going to be perceived as a threat by the victim. And I think the law probably should respect the victim's point of view of that. And also, why are guns special? So why can't I display a knife? Why can't I wave a baseball bat around? And I guess the reason for that is simply the political climate. But it's simply, there's a well-paid lobby that has convinced all of us, including that all of us, somehow guns are special, that somehow they should be treated very differently from other dangerous objects, and that's not really a rational thing. That's just sort of an emotional political thing. So I think I think the bill is a bad bill on its own merits, but also just the whole way it's written makes no sense. So there's I think those are 2 very good arguments for not passing this. So I know it's hard to say no for certain members of this legislature, say no to any bill that seems to be pro-gun, but this is a bad bill that doesn't make any sense, and it's just going to create more confusion prosecuting assault and domestic violence cases. So I just say no to this bill. As you said, certainly there is no National Knife Association that is supporting our right to wave knives around or swords around. There's no National Sword Association, no National Baseball Bat Association that wants to protect our right to wave baseball bats around and so forth. So that's probably the same thing applies to guns, even though open carry is legal in this state. So so thanks. That's my 2 cents on this. So thank you. So,
Okay, thank you very
just-
much for your
just in comment.
testimony. Are there any questions for Representative Horgan? Okay, seeing none, thank you, Representative. Margaret, who do we have next?
Daniel Itzy.
Okay, let's put him through.
Thank
Good
you, Madam.
afternoon.
Yeah, thank you, Madam Chairman, members of the committee. I am former Representative Dan Itza, and I am speaking on behalf of New Hampshire Firearms Coalition, and I rise in support of this legislation. It's very straightforward. It has nothing to do with waving anything around. It has to do with displaying, allowing to be seen, showing. I'll give you a good example. When I was in the legislature, I often carried a firearm. And on occasion, as I would get into or out of my seat, my jacket would hang up on the arm of the chair. And on occasion, certain people saw it, and someone actually complained to the speaker. Fortunately, we had a very considerate speaker, Speaker Norelli, who I guess argued to this person that it was not an issue, that it was not an intentional display. But nevertheless, this person was discomfited. I didn't hear about it except that somebody else told me that someone had spoken to the speaker. This is about protecting the ability for a firearm to be displayed in a holster, carrying it to and fro from your car as you go into the woods. It's not about waving a firearm around and threatening anybody with it. That's clearly reckless conduct. This is about giving our law enforcement clear and concise guidelines that simply allowing a firearm to be seen does not constitute criminal threatening or reckless conduct. And I'd be happy to take any questions.
Okay, thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none, thank you. Who's next, Margaret?
Alan Rice.
Okay, let's go to Mr. Rice.
Good afternoon, Madam Chair, Senator Carson, members of the committee. For the record, my name is Alan Rice, and I represent Gun Owners of America, a national organization with approximately 2 million members and supporters. I had initially not intended to testify in favor of House Bill 195. We are in support of the bill. However, I heard some comments made earlier that prompted me to sign up to speak for a few moments. Defensive display of a firearm within use of force common law is a valid and legitimate way to warn off a potential criminal attacker. If someone is threatening an innocent party with a contact weapon, such as a bat or a knife or a pipe, displaying a firearm without firing a shot is a legitimate way to warn off an attack, and the person displaying that firearm should not then be subject to criminal prosecution for reckless conduct. Criminals, even violent criminals, have their own set of pride and hierarchy within their criminal gangs and activities. And if someone says something like, you know, you need to drop the weapon, I'm armed, I can defend myself, they may or may not drop it. But when someone points a gun at them, the firearm is a far superior weapon to a bat or a knife or a club. And even a criminal with the criminal mind, in most cases, will drop the bat, the knife, or the pipe. The person displaying the gun should not then be subject to criminal prosecution for merely displaying the gun. I also wanted to comment momentarily on carrying a gun. Just carrying a gun in a holster or carrying a rifle on a sling without words or other actions, threatening comments, absent that, it's not a crime. It's not a crime today. It's never been a crime. But those who choose to carry a gun in the open should not be threatened with prosecution for reckless conduct because someone else has an unfounded fear of an inanimate object, which in this case is a firearm. My organization views House Bill 195 as a simple housekeeping bill to bring our criminal code into conformity with the long accepted common law use of deadly force and the long accepted practice of lawfully carrying guns in the open in the state of New Hampshire. And it's for those reasons I would urge this esteemed committee to vote House Bill 195 ought to pass. Thank you.
Thank you very much for your testimony, Mr. Rice. Are there any questions from the committee? Okay, seeing none, thank you. Who's next, Margaret?
Sandra Rice Hawkins.
Let's put it through.
Thank you, committee. Again, this is Xander Rice Hawkins. I'm the director of Gun Sense New Hampshire, a project of Granite State Progress. We oppose House Bill 195. As you heard, this bill would exempt displaying a firearm from the reckless conduct law. And I would draw your attention to RSA 631.3, which states a person is guilty of reckless conduct if they recklessly engage in conduct which places or may place another in danger of serious bodily injury. And that just makes sense, right? It's a basic personal liberty against armed intimidation and harassment. Reckless conduct is a Class B felony if the person uses a deadly weapon, or a misdemeanor for all other reckless conduct. This statute's so important to domestic violence protections because it also goes on to say, upon proof that the victim and defendant were intimate partners or family or household members, a conviction under this section is recorded as a, quote, reckless conduct domestic violence. And I want to thank Senators Gannon and Senator Whitley for recognizing a moment again. The domestic violence is a serious issue because it was really frustrating to have to listen to testimony that displayed a completely cavalier attitude towards the pervasiveness of domestic violence in our community. And I would heavily encourage those who spoke about it in such terms to really take the time to learn from some of our the great work being done by the New Hampshire Coalition Against Domestic and Sexual Violence and some of the centers to understand how serious this is in our society. But back on the bill itself, House Bill 195 is an attempt to exempt displaying a firearm from the reckless conduct law. It is a dangerous move because it gives a free pass to anyone who wishes to recklessly display firearms to harass, intimidate, coerce, control, or threaten others, from domestic abusers to armed extremists. It's also completely unnecessary. RSA 627.4 2A already allows a person who responds to a threat which would be considered by a reasonable person as likely to cause serious bodily injury or death to the person or to another to display a firearm with the intent to warn away the person making the threat without having committed a criminal act. The bill before you is unnecessary and dangerous. There's a reason they are trying to remove it from this section of the law instead of looking at 627.4 2A, which comes with some responsibilities about who can be about when you use that firearm, whether or not you were the initial aggressor, and other protections. So we'd encourage the committee to look heavily at each of those RSAs. I'd be happy to take any questions.
Thank you very much for your testimony. Are there any questions for Ms. Rice Hawkins? Okay, seeing none, thank you very much. And I see we have one more person left.
We do, yes, Jordan Eulery.
Okay, let's put him through.
I'm in favor of this fair bill, Madam Chairman. However, I had put my hand up as the sponsor for 108. Thank you.
Okay, thank you. Okay, is there anyone else?
We do have Representative Altschiller.
Okay, let's put her through.
Good afternoon, Madam Chair. Good afternoon, members of the committee. Thank you so much for your service.
and my name is Representative Deborah Altshuler. I represent Stratham, Rockingham District 19. House Bill 195 is very, very simple in its writing, but it seeks to add a new qualifier to an entire chapter, 631(3). And as a refresher, that chapter begins like this: a person is guilty of reckless conduct if he recklessly engages in conduct which places, and here's the important part, or may place another in danger of serious bodily injury. And then follows with this: reckless conduct is a Class B felony if the person uses a deadly weapon as defined in RSA 625. And when we dig further into 625(5)(11), we find the deadly weapon is defined as any firearm, knife, or other substance or thing which in the manner it is used, intended to be used, or threatened to be used, is known to be capable of producing death or serious bodily injury. So if a person goes walking through the aisles of Market Basket carrying a baseball bat around, they're not hitting anyone, not necessarily coming near anyone. They're not saying anything, maybe just striding through, carrying it on their shoulder. Do you think that that behavior will cause alarm? Of course it will, because a baseball bat is something unusual to carry around the supermarket. That's not normal. It's alarming, and it should be alarming. Let's say you go to a restaurant and the person at the table next to you just casually pulls out a 10 3/4 inch Whalen survival knife with the serrated edge and the gut hook, and they just put it down on the table for everyone to see. Why on earth would they do that? Ostensibly, restaurants provide their own cutlery. It's an unusual item to bring to a restaurant. That is an alarming situation, and it should be. Those instances are examples of coercive control. They're actions that are taken that send a message to the people around them that the balance of power is in the favor of the person with that weapon because they have introduced an item that is unusual to its surroundings, and in circumstances they have demonstrated a comfortableness with this threatening. That is coercive control. Neither one of these situations are normal behavior, and we wouldn't accept it. But interestingly enough, no coalition of baseball enthusiasts plan events to normalize the use of bats in places other than baseball games. There are no campaigns by hunting knife companies to BYOK trying to normalize bringing your own knife to a restaurant. But every year, this legislature hears bills that seek to normalize the presence of firearms absolutely everywhere. Bring your gun to pick up a pizza. Bring your gun to your kid's ballet class. Bring your gun to the library. Bring your gun to dinner. Bring your gun to your house of worship, or bring your gun to work, all in an effort to normalize the presence of the most lethal means of coercive control in our communities. Coercive control creates unequal power dynamics in a relationship. It's a form of violence. It is a key factor in domestic abuse and intimate partner violence. It's a part of the pattern of behaviors perpetrators use to gain power and control. Coercive control is an act of intimidation. It is a silent threat. It breaks down boundaries and it threatens safety. When someone has a firearm, they don't need to brandish it. The presence of is a threat alone. Ask any victim of domestic violence whose abuser never pointed a weapon at them, but would take it out and leave it on the table as a warning. Ask the victim whose date ended in sexual assault why they froze when the weapon came out of a glove compartment just for show. Ask the family members who lost a loved one to gun violence how normal it feels to be around people who, to their knowledge, have no permit, no training, and for all anyone knows, no background check in acquiring that weapon because private sales don't even require it in New Hampshire. I'll share with you that those are all people I have worked with, and the presence of a gun has improved absolutely none of those situations. Normalizing the presence of firearms in all parts of our lives is the goal of this kind of legislation because it sells more firearms. We should not endeavor to normalize the abusive act of coercive control. We have an obligation to the citizens of New Hampshire to create a safe community free from abuse. Article 2 of the New Hampshire Constitution ensures all persons have the right to keep and bear arms in defense of themselves, their families, their property, and the state. Often glossed over, though, is Article 1 that states our government is founded in consent and for the general good. Living under the threat of coercive control in no way contributes to the common good. I respectfully ask you to please vote inexpedient to legislate on House Bill 195. And thank you very much for your time and attention.
Thank you very much for your testimony, Representative. Are there any questions from the committee? Okay, seeing none, thank you very much. Okay, Margaret, is there anyone else?
We have no more hands raised.
Okay, I will go ahead and close the public hearing on House Bill 195. Thank you. Okay, we're just going to keep moving here. I think maybe what we can do here, because we have two more and we've got a couple of amendments, why don't we take a 15-minute break that will allow our committee secretaries an opportunity to take a refresh break, maybe get something to drink, and we will be back. I have 2:22. Why don't we come back at 2:35? Okay, and then we will take up House Bill 307. Okay, thank you. What was this stuff here?
Got my coffee.
A second, sorry. Did I hear someone say they had a chance to get some coffee?
I got some. I heated
There
up
you
my old
go.
coffee. Does that count?
Yeah, that's okay. I got the I don't know what they're Twinings infusions
I can't
that
tell.
they're like tea that you put into water. And so that's what I'm drinking.
That sounds good.
Mm.
Senator
Yeah,
French,
there's some really good
you get a
flavors.
snack?
Yeah. My,
Oh,
my
it's a
lunch.
healthy snack.
Well, that's
One
good.
want one?
I wish.
No,
I
that's
wish.
okay. I think Senator Whitley might have a hard time explaining to her son why she was eating something like that. Oh,
Right?
Do they allow?
I remember the food arguments.
Oh yeah, you have to sneak in the cupboard to eat that kind of food with a 7.
Yeah.
Fruit roll-ups? They're not allowed anymore, right?
Right.
Well, he's energetic enough. Let's put it that way.
Okay.
They're not cigars, they're pretzel rods, and they're good.
Okay. Seeing it is 12, 2:36, I'm going to take the committee out of recess, and I'm going to open the public hearing on House Bill 307. Before I begin, we have a large group of people that would like to speak on this bill. So I'm going to do what I normally do because I want to make sure that everyone has an opportunity to speak. Excuse me. So we're going to ask everyone to identify themselves, and they will be given 3 minutes to talk to us about what they believe about House Bill 307. I would also ask people not to repeat things that we've already heard. So we're interested in hearing new ideas, new opinions. So, okay, that being said, I'm going to go ahead and open the public hearing. I think I already did that, and recognize Representative Silber to introduce the bill.
Thank you, Senator, and thank you, members of the committee. For more than 10 years, we have had an RSA, which is 159:26, which is our firearms preemption statute, which says that all firearms regulation should be done by the state and no one else, municipalities, et cetera. That's because New Hampshire, unlike some states that are home rule states, New Hampshire follows what's known as the Dillon rule, which means that local municipalities can only do that which the general court allows them to do. And under 159:26, they're not supposed to make any regulation of firearms and related items. That, however, has been pretty weak in its actual implementation because a variety of municipalities have undertaken to do regulation, or what purports to be regulation of firearms and related items. So the purpose of the Bill 307, House Bill 307, is to clarify and expand the firearms preemption statute by providing for an enforcement mechanism for violations which does not presently exist. So that if some municipality does pass something contrary to the state preemption law, a citizen living in that municipality can go to send them a certified letter. They got 90 days to rescind the offending item. And if not, then they have remedies to go to court. And there's a graduated list of fines that can be imposed if the municipality persists in their unlawful conduct. It's really adding an enforcement mechanism to an existing law that's been on the books for more than 10 years. And what it's designed to do is to provide uniformity in our firearms laws so that firearms regulation doesn't vary when you cross the border from one town to another or from one county into another. It's uniform across the state. And there are many states that have done preemption. This has been modeled on other states' preemption statutes, some of which have financial penalties much greater than this. In the drafting of this, I had the assistance valuable assistance from an outside counsel of the National Rifle Association and the Gun Owners of America's outside counsel, all of whom gave input into producing the final version that's been introduced as amended. So I would urge that this be passed as an OTP to make things uniform in our state and to give some teeth to something that we've already had around for a long time. Be happy to answer any questions.
Okay, thank you very much. Are there any questions from the committee? Representative, I've received a number of phone calls on this particular bill. And let me discuss perhaps a situation with you and to get some feedback from you to help me better understand this bill. I live in Londonderry, and quite a few years ago, the town put aside land for conservation and for public use. They've created what's known as the Musquash, which is an area it's kind of like a swampy kind of a wetland area that is accessible to the public. And they had a lot of problems with people going into the Musquash and shooting, and then of course not cleaning up after themselves. There have been issues where people that live adjacent to the property, buildings have been hit by gunfire. And so in that particular instance, the town put together a group of individuals and they recommended an ordinance that there be no shooting in the Musquash. It has been a program that has worked very, very well here. So in reading through this bill, am I to understand that if a town has put in an ordinance at the request of the people, that they would not be able to do that any longer, especially when it came to firearms and the regulation or the use of where they could be used? Am I correct?
Thank you for the question. It's a good question. The problems that you described are already covered by other statutes making those actions illegal. The answer is, can the town pass an ordinance, or if they've passed an ordinance, must it be rescinded under this? Yes, unless they go to the general court and get the general court to amend this to provide a special provision for that town, for that particular facility.
Okay, so thank you for your answer. So every time a community wants to put in something like this, to put in some sort of local ordinance to control where an individual can use a firearm, that they would have to come to the general court and make a case as to why they wanted the ordinance.
That's correct. It's a question of uniformity throughout the state. The state has already said, the general court has already spoken for more than 10 years that it's preempting all firearms regulation. And the only firearms regulation that's valid is that which comes from the general court.
Okay, so what I'm hearing you say is that someone from the community would have to file a piece of legislation in order for a community to enact some sort of an ordinance concerning where a firearm can be used.
If a municipality or any portion of the state wants to adopt something that is going to regulate firearms, they need to have it done by the general court. Yes, they have to file a bill and get it heard and get it signed, get it voted on by both houses and signed by the governor to do a carve out on the state preemption. State has already preempted these things. All the existing things that exist right now just haven't been tested in court because they're illegal. They're against the firearms preemption statute that already exists.
Okay, I just have a few more questions here. Representative, we're not talking about who can own a weapon. We're talking about where it can be used. So would this affect gun ranges?
Yes. It affects anyone, any regulation of firearms and related items.
So are you saying then that if, again, I live in Londonderry, if someone wanted to open a gun range in Londonderry, they would have to ask the state for permission to open that business, or would they still go through the municipality?
The bill has a set of exceptions, and it says the subdivision shall not prohibit zoning ordinances that encompass firearms businesses along with other businesses, except that zoning ordinances that are designed for the purpose of restricting or prohibiting the sale, purchase, etc. of firearms as a method of regulating firearms or ammunition components conflict with the subdivision are prohibited. So the answer is, if you want to open a gun range and you need in a town that has gun ranges requiring a special use exception, for example, in their zoning code, you still have to comply with that, of course. Yes, that's an exception.
Okay, thank you. Are there further questions for Representative Silber?
By the way, Senator, my recommendation, seeing your schedule for today, is deep fried Twinkies.
Oh, come on now. You've got 2 thumbs up from Senator Gannon and Senator French. Well, if you're going to supply the committee with deep fried Twinkies, I'm sure both Senator French and Senator Gannon would be thrilled.
Okay.
So thank you very much for your testimony, Representative.
You're welcome.
Again, thank you. Okay, now that Representative, the prime sponsor of the bill, has testified, moving forward, we're going to ask folks to just see if they can keep their testimony to 3 minutes. And Ms. Waterhouse will alert you when you are at 3 minutes. Okay, next, we're going to go to Representative Muse.
Representative Muse, you should be able to unmute.
Oops. Thank you very much. Sorry about that. My name is Representative David Muse, and I'm one of 7 reps who represent Portsmouth in the New Hampshire House of Representatives. In Portsmouth, we're famous for our history, our shopping, and some really good restaurants. And one of the other things we probably should be more famous for that we're not are our public parks. The open spaces that we have in this community are really treasured by the people who live here, by our visitors, and by our kids. Currently in Portsmouth, we're one of those communities that has an ordinance on the books that bans bringing guns and other weapons into city-owned parks. These are places in my community that are crowded with kids, with residents, and with visitors almost every single month of the year. Right near my house, our high school cross-country team holds practices and races in one of those parks, and many of us enjoy snowshoeing and walking our dogs in those parks as well. Let me read you the ordinance in my community that HB 307 would penalize my community for if we don't wind up rescinding it. I quote, "No person in a park shall hunt, trap, or pursue wildlife at any time. No person shall use, carry, or possess firearms of any description, or air rifles, spring guns, bows and arrows, slings, or other forms of weapons potentially inimical to wildlife and dangerous to human safety, or any instrument that can be loaded with and fire blank cartridges or any kind of trapping device. Shooting into park areas from beyond park boundaries is prohibited." That's our ordinance in Portsmouth. Something I want to remind people of is that as much as we have fans in New Hampshire of Article 2A of our state constitution, we also have Article 3. Article 3 says, "When men enter into a state of society, they surrender up some of their natural rights to that society in order to ensure the protection of others." We don't hear about Article 3 a lot. We hear a lot about Article 2A. That's our right to keep and bear arms. But what Article 3 suggests is that there is a balance that we need to achieve in our laws between protecting the rights of people who own guns and protecting the health and safety of people who do things like walk in our public parks. I know a lot of folks would say that a responsible gun owner would never go shooting in a public park. But only a few years ago, police in my community had to respond to that park I was talking about that's across the street when 3 men were caught target shooting in the woods. The problem isn't the problem isn't responsible gun owners. The problem is that not all gun owners act responsibly. And
Representative Muse, the 3 minutes is up.
Okay. Do I have time to summarize my my remarks?
Yes, just please summarize it very quickly.
Yeah, thank you very much. The bottom line is this is a bad bill for my community. It's a bad bill for the state. It's bad public policy. Please stop it here. Thank you very much.
Thank you very much for your testimony, Representative. Are there any questions? Senator Whitley has a question.
Thank you, Madam Chair, and thank you, Representative Muse, for describing how this might impact your community. So with your existing ordinance, is it the case, am I reading this bill correctly, that if this law was passed, if this bill was passed, that would subject Portsmouth to a significant amount of fees and potentially attorney's fees also if it was challenged in court?
Yes, and the other thing that I did want to correct the sponsor on is if you actually read the bill itself, it's not just a member of my community who can actually file that civil lawsuit in court. It's actually anybody in the county. So you don't even have to live in Portsmouth in order to be able to file that civil lawsuit in order to rescind this. And that is essentially true for any other community that might have a similar ordinance. I understand Stratham has a similar ordinance, and there are, it sounds like from what Senator Carson was saying, Londonderry has a similar ordinance, and these ordinances are there for a very, very good reason.
Follow up, if I may?
Yes, follow up.
Thank you, Madam Chair. And if Portsmouth was subjected to this lawsuit, found to have violated the statute, charged fees, and then had attorney's fees on top of that, all those fees would be, passed on toward the taxpayers. Isn't that true?
That's correct. And they'd be passed on to taxpayers who basically, for the most part, don't have any idea that this is going on. I think one of the things that I find time after time as a legislator is how many times I'm talking about a bill that because I've been involved with it or I've heard it in my committee, I just assume that people in my community know about it. This is the kind of bill that when people find out about it, that they find out that we're actually about to pass a bill that would rescind the ability of towns like Portsmouth to ban firearms in public parks. I think most people would just be shocked. So I think one of the things that we need to have when we look at bills like this also is a little bit of perspective beyond just maybe the people who are testifying and the people who are here on Zoom or in the room today, and really understand that this is something I think that would actually come as a shock to the community.
Thank you.
Are there any further questions? Senator Gannon.
Just a quick question. Thank you, Representative, for taking my question. Have there been attacks in Portsmouth parks? Have any women been attacked, raped, or anything that you're aware of?
I'm sure that there have. There, in terms of any specific incidents.
So my question would be, what would you say to a young woman who was raped or attacked in a park if she couldn't have a weapon to defend herself, if that was how she chose to protect herself?
I don't think the issue is people defending themselves. I think the issue is opening up our parks completely to anybody who wants to carry a gun in there for any reason at all.
Okay, thank you, Representative.
You're welcome.
Okay, are there any further questions for the committee? Okay. Seeing none, thank you very much, Representative. Okay, next we're going to go to Lauren LePage.
Good afternoon. Can everyone hear me?
Yes, we can.
Great. Chairman Carson and distinguished members of the committee, my name is Lauren LePage. I'm the New Hampshire State Director for the National Rifle Association. I'll be very brief because I sent you written testimony on this as well. I'm testifying in strong support of House Bill 307. State firearms preemption was enacted to prevent a confusing patchwork of firearms laws across the state. Over recent years, numerous governments have attempted to enact gun control ordinances in violation of the current statute. This bill corrects that problem by strengthening New Hampshire's preemption statute. The potential for a myriad of local firearm laws makes compliance very difficult and nearly impossible for law-abiding gun owners. On behalf of the thousands of members we have across New Hampshire, we respectfully request your support on House Bill 307. Thank you.
Okay, thank you very much for your testimony. Are there any questions? Okay, seeing none, again, thank you. Okay, next we're going to go to Bill Herman.
Thank you, Madam Chairman, and I'll be very brief. My name is, for the record, is William Herman. I'm the town administrator for the town of Auburn. I have earlier submitted written testimony for the committee. I'll just note that we would be opposed to the adoption of House Bill 307 as presented, and would hope the committee would recommend it as inexpedient to legislate. Much like a couple of previous speakers, including the chair, as noted. I mean, there are just some places, to me, this is not a Second Amendment issue. This is a property rights issue, and municipalities having the right to say how some of their property may or may not be used. I think we would all agree there are some properties, such as a cemetery, such as a playground, such as a schoolyard, that it just would be inappropriate to discharge a firearm. That's the heart of, to me, for what this bill is asking, is the ability to discharge firearms anywhere. And we would hope you would find this inexpedient to legislate. And I'll be happy to answer any questions.
Thank you very much, Mr. Herman. Are there any questions from the committee? Mr. Herman, if you could indulge me for a few moments. Is there any property that's been set aside in the town of Auburn that individuals are not allowed to fire a weapon?
Yes, Madam Chairman, there are some conservation areas where people, and near rail trails where people walk and recreate, and recreation properties where we would not allow hunting or not seek or allow the discharging of firearms.
Okay. Now, do you, how comfortable do you feel in a process that says that if you want to maintain those areas as not being allowed to fire a weapon, that you would have to go to your local representatives and ask them to file a piece of legislation on behalf of the town of Auburn? What do you think about that process?
Well, while we have good relations with our state reps and our state senator, I would suspect you folks would not want 234 communities coming forward, because we all have properties that would be inappropriate for the discharging of firearms. And I assume we all would be looking for either special exemptions or whatever the right term would be under state law. I would note that RSA 4111A provides the governing boards of municipalities the right to manage all real properties and within the community, and to regulate their uses. That the statutes provide us the authority today to regulate local town properties. I view House Bill 307 as taking that right away.
Okay. And one final question. When the town of Auburn adopted the ordinance to prevent the firing of a firearm in a conservation area or near a rail trail, how was that done? Was that done by a committee of individuals who made the recommendation? Was this done by warrant article and the people voted? Or was this just a decision that was made by the town council?
In the case of Auburn, it would be a decision that was made by in our case, the Board of Selectmen, but with input from the public before it was adopted.
Okay. Thank you very much for your testimony and indulging my questions. Are there any further questions of Mr. Herman? Okay. Seeing none, thank you. Okay, next we're going to go to Catherine Corkery.
Catherine, if you could virtually raise your hand. I do not see Catherine.
Okay. Okay, next we're going to go to Cordell Johnston.
So Senator Cordell had to leave. Margaret Brines is going to testify on behalf of the association.
Okay, why don't we go to Margaret Brines then?
Good afternoon, Madam Chair, members of the committee. My name is Margaret Burns. I'm the Executive Director of the New Hampshire Municipal Association, and we are here today in opposition of House Bill 307. Cordell Johnston has provided written testimony that goes into much more detail on the impacts of this bill as well as existing laws, but I will just highlight a few points for you here this afternoon. House Bill 307 has been supported as necessary to protect rights under the Second Amendment. However, this bill is more properly categorized as prohibiting a property owner from managing its own property. And in this instance, because we are talking about local government, managing it for the benefit and safety of the public is what is at issue here. To be clear, municipalities are already prohibited under RSA 159, Section 26 from regulating the sale, ownership, possession, or transportation of firearms. They may not regulate the use of firearms on private property, and they cannot limit the carrying of firearms on municipal property. What this bill does is prevent municipalities as property owners from regulating the discharge of firearms on municipal property. This would include areas such as a town cemetery, a town forest where people hike with their families, conservation land, which has already been discussed here this afternoon, or even land around a protected municipal water source, creating a serious concern of lead contamination in drinking water. This bill subjects municipal officials responsible for such regulations for acting under their lawful authority under RSA 4111A to fines and the municipality to payment of liquidated damages, payment of attorney's fees for anyone who challenges the regulation, and even potential removal from office by the governor. So as a result of this legislation, a municipal regulation that prohibited discharge of a firearm near a protected water source would result in a $500 fine, liquidated damages of $10,000, payment of attorney's fees for anyone who challenged the ordinance. If the violation were found to be purposeful or knowing, the fines would be even higher, and the local officials that enacted the regulation would be subject to removal from office by the governor. Because the bill also applies to municipal property leased to a private person, this legislation would prohibit a farmer leasing town agricultural land for a farming operation from posting no hunting signs on agricultural fields. This is a situation that does exist in the state of New Hampshire in various municipalities. Simply put, House Bill 307 is a prohibition on the authority of a property owner to regulate the use of its own property. For these reasons, we urge the committee to vote to recommend 307 inexpedient to legislate. I'm happy to take any questions. Thank you.
Thank you very much for your testimony, Ms. Burns. Senator Gannon has a question.
Thanks, Ms. Burns. Too many questions today. You had said earlier you were more concerned with the discharge. When I was speaking with the representative from Portsmouth, at the beginning when he was talking, he said he was reading the ordinance in Portsmouth, and he said in Portsmouth at their parks, possession of firearms is not allowed. So you're saying that people could walk with their firearms with them? It's the discharge. Am I correct? And that's what you're saying?
Thank you for that question. What I can say is that RSA 159.26 clearly prohibits regulation of sale, ownership, possession, or transportation of firearms. So we already have state law in existence to preempt all of that. It is the firing of guns, essentially, that is at issue here.
Thank you. Even in the bill itself on line 22, page 2, it does mention possession of firearms as one of the prohibitions.
Understood, but that's already in, thank you. Yes, I understand, but that is
Okay.
already in existing state law.
Thank you.
Okay, are there any further questions for Ms. Burns? Okay, seeing none, thank you. Okay, next we are going to go to John O'Neill.
Good afternoon, Madam Senator and members of the committee. Thank you for allowing me to testify today. My name is John O'Neill. I am the Watershed Land and Property Manager for the City of Manchester, Manchester Waterworks. I take care of the Massabesic Lake watershed, the 24,000 acres surrounding Lake Massabesic as our public drinking water supply. Manchester Waterworks opposes this bill. The Water Department owns 8,000 acres of watershed protection land that has about 7,000 acres open to the public for passive recreation and hunting. However, we do face management challenges in regards to target shooting. One example is unauthorized target shooting areas that occur to have been shut down to avoid potential injury and property damage. So we've had to multiple times address these shooting ranges that kind of show up, and people it basically gets challenging in proximity to hikers and other people out, with passive recreation. The Manchester Waterworks opposes this bill, and we thank you for the opportunity to speak today. And if there's any questions, I'd be happy to answer them.
Thank you very much for your testimony. Senator Whitley has a question.
Thank you, Madam Chair, and thank you, Mr. O'Neill, for taking my question. Can you share with the committee how many people, maybe a year, come to enjoy the space at Lake Massabesic?
That's a great question, Senator. We don't have specific data for that, and I will explain why. We have about 100 different access points to our properties. So our properties we have a network of about 70 miles of fire roads that go throughout our properties, and we use it for sampling, monitoring, but the public uses them for dog walking, hiking, biking, geocaching, all kinds of different activities, including boating and everything else. But because of the various places that they enter from, we haven't been able to actually really monitor any numbers. We do have a parking area by the Massabesic traffic circle where we did do some some numbers there, and we were seeing anywhere upwards to 1,000 to 2,000 people a day. And that's a parking area that has 100 parking spots. So, and during COVID, I will just at least mention this, during COVID, we've seen our barways, which are kind of our gated areas along the roadsides, really a lot of activity during, people have been getting out, which is great, and going out and enjoying, all these activities out in the forest.
Thank you.
Hey, are there any further questions from the committee? Okay, seeing none. Thank you very much, Mr. O'Neill. Okay, next we're going to, let's see, I'm just trying to get everyone here. We got this person. We're going to go to Joseph Mullen.
Am I coming through okay?
Yes, you are.
Perfect. Good afternoon, Chair Carson, Vice Chair Gannon, and honorable members of the committee. My name is Joe Mullen. I'm from Grafton, Mass, and I'm the Northeastern States Assistant Manager for the Congressional Sportsmen's Foundation, the 501c3 nonprofit I represent before you today. I'm here to testify in support of House Bill 307. I've also submitted a written testimony to the committee. So for right now, I'd just like to touch upon some of the high-level points with my time. Requiring sportsmen and women to know the differing rules and regulations that change as one crosses a county line is an onerous ask, and it opens these individuals up to issues of liability. State preemption for firearms and ammunition and knives serves to protect law-abiding citizens from the risk of offending differing rules as they travel through these varying localities. Sportsmen and women would have a clear set of rules of what's permissible, where they can reference the laws in a concise, efficient manner. Arguably, the most important principle of providing teeth to the state's preemption law is the equal distribution of the law. So keeping firearms and ammunition regulations at the state level prevents discrepancies from locality to locality, ensuring that all gun and knife owners within New Hampshire have the same rights regardless of location. Firearms preemption not only provides equal treatment for sportsmen and women throughout the state, but also eliminates the risk of committing a crime by just crossing a county line. Through consistency, individuals will be able to enjoy their time-honored sporting traditions without cause for concern while traveling throughout the state. So once again, I would just like to reiterate my support for HB 307. I'd like to thank you for your time.
Thank you very much for your testimony, Mr. Mullen. Are there any questions from the committee? Okay, seeing none, thank you. Next, we're going to go to Sean Mulholland.
Good afternoon. My name is Sean Mulholland. I'm the city manager for the city of Lebanon, and I'm in opposition. The city's in opposition to this bill. I won't reiterate what's been said by others. I'll just focus on one narrow issue. We have a summer recreation program where we have children that participate in that. And the way I read this bill would prohibit us from having rules that would prohibit children from carrying knives or firearms. In my previous life, I was a chief of police, so I understand some of these rules and regulations as they apply. And some would say, well, federal law already takes care of that, but that's really not the case. The federal government does not have a juvenile justice system. It can only charge people as adults. And not only that, our local law enforcement does not have the authority to enforce federal law. Only the federal government has that authority to do that. So trying to get an FBI agent or an ATF agent to come up here any given day during the week would be a bit of a challenge in the time it would take for them to respond to do that. So that would practically prohibit us from being able to prohibit firearms and knives for kids that are participating in these programs. And I don't think that's really the intent of what folks want to travel down that road, but that is indeed what the effect will be. It would prohibit us from being able to take any action on that or prevent that from occurring. And if there's any questions for me.
Thank you very much for your testimony, Mr. Mulholland. Are there any questions from the committee? Okay, seeing none, thank you. Next, we're going to go to Charlie Dennis.
Senator Carson, can you hear me?
Yes, we can.
Well, good afternoon, Senator Carson and members of the committee. My name is Charlie Dennis. I'm the police chief in Hanover, New Hampshire, and I'm here today in that capacity in opposition to House Bill 307. I'm going to try to dance around a little bit and not repeat what other people have said. I think the committee's pretty clear on what this opens up for local municipalities, of the concerns about the use of a firearm and that use being allowed on town or city-owned properties. And certainly, you know, there's areas that are opened up. Some of those have been described, or there's a cemetery, it's a closed municipal landfill, a town reservoir, you know, many places where that would open up for someone to come and discharge a firearm. You know, my biggest concern is that of the public safety. Communities all across New Hampshire, including Hanover, are riddled with walking trails and hiking areas throughout them. Many of those are next to residential neighborhoods. They're all open to residents and visitors alike to use and enjoy the outdoors. And by allowing anyone to show up on a town-owned property as described and begin discharging their firearm, it'll create a significant public safety issue for our community members that may be out walking or hiking through some of these areas. I believe this should remain a local decision to where towns can decide of land that's under their control whether firearms could be used and discharged in those areas. I thank you for your time, senators, and happy to answer any questions.
Thank you very much for your testimony, Mr. Dennis. Are there any questions from the committee? Okay, seeing none, thank you very much. Next, we're going to go to Paul Dean.
Hi, thank you, Chairwoman Carson, and members of the Judiciary Committee. My name is Paul Dean, and I'm the Chief of Police at the University of New Hampshire, and I'm here speaking on behalf of the university system and the community college system of New Hampshire. I'm going to give you just a little twist on what others have spoken about. Looking at this statute, we believe would be the equivalent of campus carry on our college campuses. Looking at the RSA under RSA 159.28, we feel that this would prohibit the University Board of Trustees and their statutory authority to have policies that ban and prohibit firearms on campus, and the obvious safety issue that would create. We feel that our policies have been in place. I've been before the Honorable Court at least 6 times talking about this, and colleagues other than yourselves have supported the idea that colleges and university campuses are not the place for firearms to be readily available. However, by our policies, we're able to be flexible. We do provide space for students, faculty, and staff to store firearms. We store them here at the police department. Our properties that are not in the core campus are open to hunting, where we permit hunters to be out there. So it's not a complete ban. However, we don't believe that firearms inside of dormitories, inside of buildings, is really there for the educational mission and the educational purpose. And I'm sure I don't have to tell you that 18 to 25-year-olds on weekend, Friday nights and Saturday nights consume alcohol, and having firearms readily available for somebody in a residence hall could be an issue. Additionally, we've seen an increase, and you're probably already aware, of mental health issues throughout the state. 18 to 25-year-olds are some of the highest of those, and we've seen, unfortunately, our share here at the university. So we would strongly recommend and oppose this, and it'd be expedient to legislate. Thank you.
Thank you very much for your testimony this afternoon, Chief. Are there any questions from the committee? Okay, seeing none, thank you. Okay, next we're going to go to Alan Rice.
Good afternoon, Madam Chair, members of the committee. My name is Alan Rice, and I am with Gun Owners of America. I have submitted detailed written testimony to your committee, and I will use my short 3 minutes to comment on some of the previous speakers. We already have a preemption law in the state of New Hampshire. The municipal association and the speakers from several towns have admitted that. They've also admitted they're breaking the law by prohibiting the mere carrying of firearms in these town-owned properties. House Bill 307 is not in any way change where a person can carry a gun. It provides an enforcement mechanism. When Florida passed a similar law, nobody actually paid the fines. They brought their local laws into conformity with state law, and they stopped the illegal gun bans. And that's exactly what House Bill 307 is intended to do. These municipal ordinances and Chief Dean's rule at UNH, those are just that. Those are rules. Those are not statutory laws. Carrying a gun at UNH or in the Musquash Swamp or the place in Auburn or the place in Hanover, those are not crimes. And the person carrying a firearm is not committing a crime. The crime is being committed by the governing body that's enacted these illegal local ordinances. House Bill 307 is intended to get rid of the illegal ordinances through voluntary compliance. But if the towns refuse to comply, there's an enforcement mechanism that allows the aggrieved to go into court. And those and the reasons in my letter to this committee are why Gun Owners of America is asking you to vote House Bill 307 ought to pass, and I will be happy to take any questions.
Okay, thank you very much, Mr. Rice. Are there any questions from the committee? Okay, Senator Khan has a question.
Well, Madam Chair, it's not directed at Mr. Rice, but it would be directed at Chief Dean. I believe that there is an exemption that is specific in statute for the university system. And if he's still available and can just clear that up for us so that we don't have misinformation.
Okay, thank you very much, Senator Khan. He might still be here, and when we get through everyone, we'll see if he would like to speak again. Okay, thank you. Okay, are there any questions for Mr. Rice? Okay, seeing none, thank you very much, Mr. Rice. Okay, next we are going to go to Scott Myers.
I see City Manager Myers. I'll bring them in.
Thank you, Madam Chair and members of the committee. My name is Scott Myers. I'm the Laconia City Manager. I'm here today speaking in opposition of House Bill 307. I want to be clear that the city of Laconia is not breaking any state law. We understand that the people have the right to possess firearms on city property. But what is not in state law right now is for their ability to discharge them on all city property. So that is what I'm in opposition to. I won't repeat a lot of what's been said already today that I agree with. I would like to give you one or two examples. There may be large tracts of city-owned land where we certainly welcome and encourage hunting. There may be a new purchase we just did for conservation for about a 2-acre parcel, giving members of our community access to Pickerel Pond to walk in with kayaks and some passive walking trails that we don't feel, it being a very small parcel with that type of activity, is appropriate for the discharge of firearms in that property. So that's where, Madam Chair, I think you brought up an example in your community. I think local communities know what's best on certain parcels within their own municipal boundaries. We also own a municipal airport, which every community does not. We know there's fenced in areas, but is it really appropriate for firearms being discharged right outside of a fence of an airport? One final thing that no one has brought up is this bill would also prohibit municipalities or even the state from regulating firearm accessories. My understanding is that something like tannerite, which has been in the news lately, is a firearm accessory. I'm not sure if any of us would want to have those types of accessories going off in our communities. So again, I am in opposition to this. Be happy to stop here in respect of your time and take any questions you may have.
Thank you very much for your testimony, Mr. Myers. Are there any questions? Senator Gannon?
Yeah, just help me, Mr. Myers, if you've read the bill, right?
Yes, I have.
Where does it mention discharge? It's probably, I'm just overlooking it and I apologize for that. I see
Well,
possession and all these other things.
I believe the word is use. So in between.
Okay, the sale.
So I think it was referenced earlier today as discharge. So I was just trying to go with the same
I
language.
didn't have my glasses on, so my fault. Mea culpa. Thank you.
You're welcome.
Okay, are there any further questions for Mr. Myers? Okay, seeing none, thank you very much, Mr. Myers. Okay, next we're going to go to Tracy Han Burkett.
Hi, can you hear me?
Yes, we can.
Thank you. Just for the record, I'm Tracy Han Burkett, and I'm leader of the Kent Street Coalition's Working Group on Gun Violence Prevention. I will try not to repeat things that people have said and just highlight some points that maybe haven't been aired as much. Testifying in opposition to HB 307. And really, I have rarely seen a bill that is so devoted to eliminating the ability of officials and community leaders to protect their own communities. And one of the things I want to highlight and emphasize is the deliberate harshness, which is really uncharacteristic of our democratic system of government, of this bill in punishing jurisdictions with substantial financial penalties and in penalizing officials with the potential loss of their positions for just trying to do their jobs, which is, if they're elected officials or if they're school officials, college officials, their jobs of looking out for the people they're charged with keeping safe. Just to drive that point home, the bill makes sure to point out that acting in good faith is not a defense. It literally punishes officials for trying to do good. And so basically, I'm just going to turn to a few real life examples of the effects of the bill, rather than go through various provisions of it. Not only is it about where you can bring or not bring firearms, but no one also can make rules about how you carry guns in schools or to concerts or wherever in schools or towns. So you can't make rules about how you bring a gun to a school trip or on a town library. Nobody can say, make sure the guns are locked and unloaded. Keep your gun in a locker or stored away. And let's also consider the fact that school buses would be part of this. The school drivers can be carrying a loaded weapon. Any chaperones on a school trip could be carrying a loaded weapon. So this is all taking place in an environment with a bunch of kids. And I think others have and will continue to speak about colleges and universities. But one thing I haven't heard much about is that in the bill, private contractors who do business with state universities couldn't have any restrictions on firearms or knives on university property for their employees or any events. So take, for example, a caterer. No restrictions. An engineering firm maybe who's working in partnership with a university using their labs and working with students, no restrictions. Even an organization that's holding a support event for victims of violence, no restrictions. They all
Ms.
must.
Burkett, we have reached the 3-minute mark.
Okay, let me just sum up. So even that organization holding a support event for victims of violence has to permit people to carry loaded firearms to their events. So the bill doesn't balance the interests of gun owners with the interests of public safety, and I would urge you to vote to ITL this bill.
Okay, thank you very much for your testimony. Are there any questions for Ms. Han Burkett? Okay, seeing none, thank you very much. Next, we're going to go to Eric Sawtell.
Eric, if you could virtually raise your hand. I do not see Eric.
Okay, next we're going to go to Barbara Prian.
Good afternoon. Thank you, Madam Chair and Judiciary Committee members. My name is Barbara Preen. I'm a resident of Rye and a parent of 2 and grandmother of 3 granddaughters. I'm a former New Hampshire educator who retired after 33 years of teaching predominantly 2nd grade. I'm speaking as a citizen in opposition to HB 307. I've submitted this in written form. I come here today to ask you to reevaluate and reassess the implications of the new proposed restrictions that HB 307 places on the school board, administration, faculty, and staff of each of our New Hampshire school districts when they are simply attempting to protect the children under their care. To put more extreme restrictions on local gun regulations, which are designed solely to safeguard the children in our public schools by threatening possible loss of employment and livelihood and overwhelming fines, serves no productive purpose. Guns have no purpose in a school unless carried by persons authorized by school officials for the explicit protection of those who work there or those who are there to be educated. There is nothing inherently threatening about entering a school or being inside of a school. In turn, there's no need to protect oneself when visiting a school. There's absolutely no reason for anyone else to have a firearm on their person except for the intent to do harm or to intimidate. I ask you to consider how those in charge of protecting the students are to know who is simply a visitor with a gun or an individual who has the intent to do harm. And now this bill will allow for unreasonable penalties on localities and on persons who attempt to limit a gun being brought onto the school grounds or into the school. Children are taught to say, if you see something, say something. How is an adult supposed to respond to that reporting now? How are children supposed to feel safe when they see a gun being carried in a hallway? How do administrators know when to activate the protective protocols that children practice in case of an emergency? This bill will result in a reluctance to act. I ask myself, does this mean that surveillance entrances into schools have to be disbanded? Do metal detectors have to be removed? And what is the purpose of an on-scene school safety officer? Also, again, why is a gun even needed in a school by someone not employed there, unless it is that they have brought it to intimidate? When someone that's in the administrative office or in the distinct classroom of a particular faculty member or a student or in a meeting, intimidation is a form of threatening. Knowing other laws in New Hampshire allow for guns in school by an adult over 18, and then the possible addition of HB 307 also made me wonder, well, where other places in New Hampshire would this take effect? And I've heard testimony about that today. But then I was wondering about the state courthouses. I know that there are laws that protect and state that people cannot take guns into the courthouse. I've been a juror 3 times, and I've gone through the process of checking in each day.
Excuse me, Ms. Preen, we have reached a 3-minute mark.
I asked this committee to vote against HB 307, and I ask you not to pass this bill. Thank you.
Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none, thank you. Next, we're going to go to Cindy White. Good afternoon, Ms. White.
Good afternoon, Madam Chairwoman and members of the committee. My name is Cindy White. I live in Hopkinton. I'm an attorney and a former senior assistant attorney general, and I am adamantly opposed to HB 307. There are many problems with this bill, but one glaring one that no one has mentioned yet is that it's unconstitutional. It allows any citizen of the state who believes himself to be aggrieved, or any organization whose membership is, quote, aggrieved, by an ordinance, regulation, or policy believed to be adopted in violation of the law, to file a lawsuit in the Superior Court. And it provides that such citizens and organizations are, quote, deemed to have standing, which is the threshold someone has to pass in order to bring a lawsuit in court. The bill further provides that if citizens and organizations who petition prevail in a case, the court is required to award $10,000 in liquidated damages, as well as attorney's fees and costs. Now, the obvious problem with this is that believing oneself to be aggrieved does not give a person or entity legal standing to sue in court. Courts look to the dictionary definition of words in statutes, and the dictionary defines aggrieved as having a feeling that one has been wronged. That is very different than demonstrating that a person or entity suffered a definite and concrete personal injury, or that its personal rights were impaired or prejudiced. That is the showing that's required by Part 2, Article 74 of our state constitution to have standing to bring a lawsuit. And the New Hampshire Supreme Court has made it clear. It has come right out and said that the legislature does not have the authority to do what this bill is trying to do. It does not have authority to grant standing to those who do not meet the constitutional standard for standing. And it's easy to see the ridiculous consequences that could flow from passage of a bill that is deeming citizens and organizations whose members feel aggrieved to have standing to sue, and entitling them to liquidated damages without any showing that they've been injured or prejudiced. A school district or town could adopt a policy prohibiting guns in its schools or on its property like conservation land. Then a person who lives in that town, or, and this is important, an organization like the NRA with a membership that believes itself to be aggrieved but has no connection to that school district or town, could sue the district or town. If that person or organization prevailed, it would be entitled to a windfall of $10,000 in damages without ever having been denied entrance into a school or into the conservation area with the gun, maybe even without ever having been to those places. So it's not surprising to me that the NRA is supporting this bill and helped draft it, because this bill was designed perfectly to help that organization replenish the coffers of its bankrupt organization. It could get $10,000 with every lawsuit that it brings without showing any damages at all.
Ms. White, we have reached the 3-minute mark.
Okay, I will just sum up by saying it's terrible policy. Also, it's unduly harsh. It requires courts to order $500 fines for inadvertent and negligent violations of the laws, and also provides that a government entity acting in good faith or upon the advice of counsel may not raise that as a defense. For those reasons, I would ask the committee to vote inexpedient to legislate.
Thank you very much for your testimony this afternoon. Are there any questions from the committee? Senator Gannon.
You're on mute, Senator.
Bill, you're muted.
Probably a good reason for that. But help me with aggrieved counsel. Wouldn't to be aggrieved, wouldn't you have to have suffered injury, like you were denied carrying your gun on a property or something? Wouldn't there have to be an actual incident to be aggrieved?
Well, the bill does not say that. The bill provides no definition of aggrieved, and under the state case law, when there's no statutory definition, then the Supreme Court will look at the common and ordinary meaning of the word. They look to dictionaries, and I read you the dictionary definition, which definitely does not require any actual harm or prejudice. It's just having a feeling that you've been wronged.
I'll grab my Webster's out later. Thank you, Counsel.
Sure.
Okay. Are there any further questions from the committee? Okay, seeing none, thank you very much for your testimony this afternoon. Next, we're going to Deborah Nelson.
Good afternoon, Senator Carson and other
Good
senators.
afternoon.
Thank you very much for allowing me to speak. I've been listening since 1:30, and I have to confess I have feelings of increasing dismay. I want to speak to you today in opposition to Bill 307. I speak as a public school teacher who was in the classroom before the Columbine shootings and for almost all of the 22 years that have followed. I've witnessed student anxiety, endured countless active shooter drills, and watched as tensions only heighten over the issue of guns. Without exception, my students want to feel safe in school, and yet local school boards, and I want to emphasize the word local, cannot prohibit spectators from coming to sporting events, dramatic productions, or musical performances while carrying a loaded weapon. There's a sign alongside the local lacrosse field, and I live in the town of Hanover. And the text on that sign, it's right next to the field in the parking lot, prohibits dogs, cigarettes, and alcohol. But the most substantial danger to student lives and the public is apparently welcome. I have witnessed local school boards, Dartmouth College, town governments, seek to keep facilities gun-free, only to be overruled by the state. What has happened to the time-honored tradition of local control? The provision that fines and possibly removes from office those who pass gun safety restrictions desired by a local community just don't make sense to me. And these guidelines, so Dartmouth College has clear guidelines for weapons on campus, including their storage. They've had them for decades. I used to be married to the dean of the college. And these guidelines, still in existence, made the entire town feel reassured last fall when, because of social distancing required by the pandemic, our state primary and November election was moved to the voter site was moved to the field house at Dartmouth. What possible benefit is attached to interfering with the oversight of local school boards, local municipal workers, local colleges and universities as far as guns are concerned? I mean, that really, I think, is the ultimate question. I urge the committee to resist the inflammatory language of those who argue that a healthy democracy must be fully armed everywhere and at all times. That is not the definition of a democracy. This is the definition of dangerous mayhem. The lives of my students and my community
Ms. Nelson, we have reached the 3-minute mark.
Are at stake. 3 words short.
Close, very good.
Very close.
Thank you so much for your testimony this afternoon, Ms. Nelson. Are there any questions from the committee? Okay, seeing none, thank you very much. Next, we're going to go to Suzanne Sonborn.
Ms. Sonborn, you should be able to unmute.
Okay, how's that? Can you hear me?
We sure can.
Okay, great. Thank you, Madam Chairwoman and Senate Judiciary Committee members. My name is Suzanne Sonneborn. I am a resident of Rye, a retired registered dietitian nutritionist, a former Rye school board member, a mother and a grandmother. I come before you today in opposition to HB 307, a dangerous and punitive bill that greatly weakens protections against gun violence and weakens our community's ability to enact and enforce ordinances that have proven to be effective in protecting our citizens. As it exists today, New Hampshire cities, towns, and other local jurisdictions are barred by law from establishing and enforcing ordinances and regulations around firearms that they find reasonable in the protection of their citizens. These ordinances and regulations can be tailored specifically to meet the needs of that local community, and in many states provide life-saving tools to prevent gun violence. The City of Manchester's needs are not the same as those in Jaffrey or Londonderry or Plymouth or Durham. These locally enacted regulations and ordinances could be instrumental in creating an added barrier of protection against individuals who might attempt to do grave harm to the people in those communities, and also while addressing our state's firearm suicide epidemic. Unfortunately, our state's preemption law prevents them from doing so. And now, instead of rolling back that preemption law and empowering localities to take steps to protect our communities, the general court is instead pushing HB 307, a bill that would needlessly and dangerously expand the preemption law. This heavy-handed and ill-conceived preemption expansion would allow individuals out of state gun groups and the gun lobby to sue local jurisdictions if any attempt is made to regulate firearms and their myriad components. This bill would add new punitive elements to the state's law that already bars local gun safety ordinances. These changes would authorize lawsuits against localities and require them to pay plaintiffs' damages and attorney fees. It would also line the pockets of out-of-state gun lobby groups by allowing them to bring lawsuits against New Hampshire cities, and if they win, forcing courts to award damages of at least $10,000 plus attorney's fees. These punitive elements are meant to threaten and intimidate public servants who want nothing more than to work to keep the people they serve safe. It is not unreasonable that a school board might wish to keep firearms out of its kindergartens and elementary schools. It is not unreasonable that a town might wish to do everything they can to keep someone with a loaded gun off of the high school grounds. It is not unreasonable that Durham would like to take the steps that they can to keep firearms out of the hands of 18 and 19-year-olds dealing with the pressures and influences that are part of daily college life. Mental illness is a significant problem among college students.
Ms. Sonneborn, we have reached the 3-minute mark.
Okay, great. I will just end by saying that I ask you not to move forward with House Bill 307. Thank you for your time.
Thank you so much for your testimony. Are there any questions from the committee? Okay, seeing none, thank you.
Thank you.
Next, we're going to Deb Nelson.
Deb, if you could virtually raise your hand. I do not see Deb.
Okay. Next, we're going to go to Clyde Bacon.
Clyde, if you could virtually raise your hand. I do not see Clyde.
Okay. Okay, that is the list that I have of people who have signed up to speak. I see that some folks have their hands raised. So let's go to the folks that have their hands raised.
All right, I'll start with Daniel Itzy.
Thank you, Madam Chair, members of the committee. I am former Representative Dan Itza, and I am speaking on behalf of New Hampshire Firearms Coalition. I do support this legislation, having sponsored similar legislation in the past. It's important to remember that this does not change what is legal and illegal in the state of New Hampshire one iota. It is simply about the Constitution, Article 2, but Part 2, which says the supreme legislative power within this state shall be vested in the Senate and House of Representatives. The issue is that we do not have home rule in this state. It is the legislature which makes the laws in the state of New Hampshire and enables the towns and to, and counties to make laws pursuant or ordinances pursuant to their laws. Ms. White made reference to, I believe, Part 2, Article 74. I think she was pointing to the wrong article at the very least, because Article 74 gives the legislature and the governor the power to ask opinions of the court. It says nothing about what kinds of cases can be brought before the judiciary. She was probably referring to 73A, but the Supreme Court itself has recognized that when court rules are contrary to legislation or state law, statute, that it is statute that overrules the court rules. In the end, it is the legislative power of the general court that is supreme in the state of New Hampshire, including over the Supreme Court. This is simply about making what is already illegal punishable. That's it. The language in House Bill 307 exactly mirrors the language in RSA 156:26. So there is no difference. It simply says that what is against the law is against the law and can be punished. I would be happy to answer any questions.
Thank you very much for your testimony. Senator Gannon has a question.
Representative Itza, one of my mentors. How you doing?
I'm doing well. Thank you, sir.
Well, I appreciate the Second Amendment a lot. I appreciate one thing that the other side, especially the city managers and Chairman Carson talked about with her local pond in an area. It's the word use in prohibitions. Is that a word you could live without? Because they're scared someone's going to get shot. And
I would say that if I was going to attack it, I would attack it more positively. First of all, the word use is already an existing statute. That's not new. Okay.
Nope, I understand.
So whatever you do, you have to do across the board. And if you wanted to empower the towns to limit the use of firearms only for self-defense in conservation lands or whatever, that's up to you as the general court. That's what your job is.
Yep. Okay. Thank you. Thank you, Representative. Good to talk to you.
Are there any further questions for Mr. Itzy? Okay, seeing none, thank you very much. Okay, who's next?
Representative Horgan.
Okay, we'll put them through.
Well, thank you very much. I don't want to repeat too much what Chief Dean, who's the chief of the UNH police, said, but he was like 100% correct about the need for gun regulations on campus. And I believe this bill, it's a very, very far-reaching bill, and I think I think the sponsors, well, we haven't really heard that much from the sponsors aside from Reverend Silber, but I think it's actually intended to force public educational institutions to have guns on campus, and that's extremely unwise. So the minimum you need to put in some language clearing that issue up. I'm a former resident of Hanover. Dartmouth has extensive gun rules on campus, and for good reasons. I'm not sure why UNH, which is aside from who's on the board of trustees, is it's the same type of institution as Dartmouth should not be able to make the same rules to protect its community as a school like Dartmouth does. Of course, I suppose you turn that the other way around. Some might argue that maybe all universities should be forbidden to prohibit guns, but that's like I guess that's probably not an argument worth pursuing too far. So I think certainly and town governments too certainly have reasons. There's good reasons, for example, for rules in Portsmouth about guns. So I think this bill goes totally in the wrong direction. So if the only worthwhile thing you can do with this bill is to get a bill that clarifies and allows public institutions and also municipalities and other public entities to protect themselves. And there's like a myriad of problems. Like, for example, the city of Laconia owns a airport, and then they're not the only city that owns an airport. And certainly, like in case of Manchester Airport, not only is that an airport, it also contains a number of restaurants that serve alcohol, and there's a lot of rules about firearms in those establishments, and there's just a host of things. So certainly, you certainly should not pass this bill as it came over the House, and probably the best thing to do this time is kill the bill and do nothing with it at all, because that's that'd be politically a huge task, making a bill that properly meets all the concerns of the municipalities and other public institutions. So that's I think it's a bill. It's especially bad idea for my community, which is a college town, but I think it's a bad bill for any part of the state. So that's what I have to say. Thanks.
Okay, thank you very much for your testimony, Representative. Are there any questions from the committee? Okay, seeing none, thank you.
Thank
you. Okay, let's go to the next one, Margaret.
All right, Jonathan Weinberg.
Hi.
Good afternoon.
Good afternoon. Can you hear me?
We sure can.
Amazing. Thank you. My name is Jonathan Weinberg. I'm a member of the Concord School Board. However, I'm here in my capacity as an individual and not representing the views of the board. I'm here in strong opposition to House Bill 307. It is not beyond any of us the pervasiveness of gun violence in our country. Recently, we have witnessed how gun violence has upended families, communities, and reinvigorated calls for common sense gun reform. As a member of the school board, I'm concerned by how this bill will harm a district's ability to create safe schools and safe environments for learning, which is what all of us want. This bill penalizes educators, administrators, and school employees for acting in good faith, and it cannot be said enough that schools are not a place for guns. Lastly, you have only heard support today from those in the gun lobby, whereas you have heard countless opposition from multiple municipalities and law enforcement agencies about this bill. And I urge you to trust those who have been elected to represent their constituencies and those who serve and protect their communities. Thank you.
Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none, thank you. Let's go to the next one, Margaret.
All right, Raymond Belanger.
Okay.
Hi.
Good afternoon.
I'm a citizen. I'm retired. I'm a bicyclist, cyclist. And I keep listening to everybody talk, and they keep bringing up firearms in schools. And this bill is so much broader than dealing with firearms in schools. It's dealing with a person's ability to travel across the state and feel safe if carrying a firearm makes him feel safe without having to worry whether he goes into an area where the firearm that he has on is illegal. I rode a rail trail yesterday from Wolfboro to Wakefield, and I went through 3 towns in my travels and did not have to worry that I was going to pop out in a park. And you went through maybe 4 of them on that trail, where if a police officer happened to notice that I had a concealed weapon, he could arrest me. That's what, and town after town, Nashua did it. A couple of towns have tried creating local ordinances to keep guns out of certain places, and were shot down because they're unconstitutional, so that citizens can travel freely across the state without worrying about getting arrested. I know a park that has a sign up that says there's no weapons. It is at one end of a bike trail, or close to one end of a bike trail, where a person might stop to go to the bathroom or to rest and enjoy the river flowing by. And I mentioned to the town that the sign include the Parks Department put it up, not considering the town officials. And when I pointed it out to them, they said, oh, well, you have a concealed carry permit, so you're okay. Well, the police officers that might be there when there's a band concert will look at that, and if I raise my arm and my sidearm, which is concealed, becomes holstered, they might want to arrest me. And I tried going to the town and getting them to change the sign, and they just handed me a letter saying, okay, you're approved. And the town officials tend to ignore state preemption law. And if you start giving people the ability to make them pay a fine, they might start thinking twice about stepping on local citizens' rights. Going to a school, people who are worried about people with guns going into schools, people aren't going into that school because they fear that they might need the firearm in the school, but they might have to walk through a terrible neighborhood where they could get mugged. And they're not just going into the school, they're going from their home to the school and want to feel safe in between those locations. That's what preemption is all about. For me to go up to Dartmouth and have them have a local law when I
Mr.
want
Belanger, we have reached the 3-minute mark.
Okay, well, you got my idea about how important local preemption is. It really needs to stand the way it is, and since they're ignoring it now, maybe they need another tool to help them pay attention. Thank you.
Okay, thank you very much for your testimony, Mr. Belanger. Are there any questions from the committee? Okay, seeing none, let's go to the next person, Margaret.
All right, Zandra Rice Hawkins.
Okay.
Hello again, committee. Xander Rice Hawkins, Gun Sense New Hampshire, a project to grant state progress. A lot of our opposition to this bill has already been stated, so I would just re-emphasize that this bill adds new punitive measures to intimidate, punish, and bankrupt local communities and school districts. These penalties apply even though the legislative or governing body believed in good faith that it had the authority to enact the regulation, and even if their attorney advised them that it was legal to do so. So this is very punitive. It also allows them to be sued in court for $10,000 plus attorney fees, and makes the enactment or enforcement of local public safety regulations grounds for termination of public employees or removal from public office by the governor. And we just have to point out the incredible double standard here. This bill seeks to have the governor unilaterally remove an elected official from office for trying to protect their community from violence. But at the same time, the governor and state legislature have not done anything about state legislators who share racist, anti-Semitic, and sexist messages that encourage violence. So we'd really ask this legislative body to focus on some of the real issues facing our state. I also want to take a moment to answer some of the questions that Senator Gannon asked earlier about possession of a firearm versus usage, which are great questions to draw out because it is very different. For municipalities, it's not about carrying. As you heard, there are already laws on the books that preclude them from making different statements about that, but it is about discharge of firearm in public places. But for schools and colleges, it's really about both. And you heard earlier testimony about, we don't want to have a situation on college campuses, for example, where we're mixing guns and alcohol, or guns in the intersection of mental health. Or for Senator Gannon's question earlier about sexual assault, thinking just about college campuses themselves, allowing students to carry loaded firearms actually doesn't prevent sexual assault. In fact, the evidence shows that it makes it worse. 1 in 5 women will be sexually assaulted while in college, and 32% of female students report having been abused by a dating partner, and guns are the most common weapon used in the murder of intimate partners. So while some may suggest that allowing students to carry guns would protect them from being victims of sexual assault, the truth is the vast majority of campus rapes are perpetrated by the victim's partner, their friend, or close acquaintance, precisely the people around whom victims never would think to carry a gun, let alone use one. And we know that the presence of a gun in a case of a domestic violence situation makes it 5 times more likely that the victim will be murdered, regardless of who owns the gun. So I do think that those are really important factors to consider while you're talking about this. And I would really discourage the committee from looking at trying to amend the bill in some way to talk about carrying versus usage. From start to finish, this bill is very punitive for municipalities and school districts. It puts guns in spaces that they really ought not to be, and it's just not a bill for New Hampshire. So I would be happy to take any questions.
Thank you very much for your testimony. Senator Gannon has a question.
Thanks for taking my question. Senator Khan brought up earlier, and he, being a past president of college, probably knows, aren't there already laws on the books separating the university system?
So it is our understanding that that the sponsors and supporters of this bill are really trying to force a situation where municipalities, school districts, and college campuses do not have any opportunity to have common sense public safety guidelines or regulations. And so I would go back to what the intent is, and I think you heard from a couple of the bill supporters earlier that really is their ultimate goal. Whether or not the college system feels like it would not be impacted here, I think the presence of some of the individuals testifying on behalf of the college and university system says that they do have concerns.
Thank you.
Thank you.
Okay, are there any further questions for Ms. Rice-Hawkins? Okay, seeing none, thank you very much, Ms. Rice-Hawkins. And we have one more speaker. Margaret, who do we have?
We have Raymond Belanger again.
Okay, well, we'll go back to Mr. Belanger.
I again, I keep speaking to the woman just spoke, that people keep bringing this back to specific instances on campus or domestic abuse. And as far as I can see reading this, it has not, this bill has nothing to do with anything like that other than making sure that towns and cities do not make laws that are unconstitutional. It's unconstitutional to go on to UNH. I mean, it's against the law, I think, to go on to some of the campuses like UNH already. This law isn't changing any of the laws that are in place. It is only safeguarding citizens from being arrested in places where they were once legal and become criminals. It would, you know, when municipalities create laws that are different in their town to the town before, the outcome is that you make criminals of law-abiding citizens, and you shouldn't do that. And since they're not conscientious enough to the citizens of their town and neighboring towns to make laws that are going to get them in trouble, then the state has to put in tools for people to make sure they abide by the state preemption laws. Thank you.
Thank you very much for your testimony. Are there any questions for Mr. Belanger? Okay, seeing none. Is that it, Margaret?
Actually, we have 3 hands raised now. We have Cindy White, Chief Paul Dean, and Thomas Mullins.
Okay, all right, we're gonna have these 3, but if these folks are calling to, you know, go against something that somebody else has said, I don't think we want to get into the going back and forth between individuals, but very quickly, we're going to hear from these folks. And so let's put them through one right after the other, Margaret.
All right, here's Cindy White.
Good afternoon, Ms. White again.
Good afternoon. I just wanted to briefly respond to what Dan Itza suggested. He suggested that I was pointing to a different constitutional provision than I was. So I think it's important to correct that. There's a New Hampshire Supreme Court case, it's State versus Duncan, and I will submit that to the committee in writing, but it is relying on Part 2, Article 74, as I suggested before. And it says the constitutional authority of the court to give advice as set forth in that constitutional provision cannot be extended by legislative action. In that case, the court found that a statute contravened Part 2, Article 74 because it conferred standing upon plaintiffs without requiring them to demonstrate that any of their personal rights were impaired or prejudiced. And the reason for that is that if there's no standing, if there's no personal stakes or personal prejudice in a case, then a court is really just giving an advisory opinion, and the Constitution does not allow it to do that, as that provision says.
Okay, thank you very much for your testimony. Senator Gannon has a quick question.
Quick question, Ms. White. Thanks for taking it. I did look up aggrieved, and I did see your part about feeling resentment, but they'd have to be at the base. They'd have to have been an unfair treatment. And I believe that could give you standing, but that's just the way I read it.
Okay.
Okay, Thank you very much, Ms. White. I think we have one person left, Margaret.
Yes, Thomas Mullins.
All right, let's put Mr. Mullins through.
All right, good afternoon, members of the committee, Madam Chair, Tom Mullins. I'm the city attorney in Keene, actually, sort of waiting for the next series of events for the committee to come up on the right to know law. But I thought I'd speak anyway on this, especially to Senator Khan's question. I don't know whether or not there's a specific statute with respect to the college community in possession of a firearm. But one of the things I wanted to point out is that this bill is currently written doesn't include a key provision of 15926, which is the existing statute everybody is referencing. While the existing statute does have a lot of the same language in it with respect to preemption for ownership, purchase, use, all of the rest of it, that 15926 as it's currently written, also with section 1, as a matter of fact, also has this key language in it. It says nothing in this section shall be construed as affecting a political subdivision's right to adopt zoning ordinance for the purpose of regulating firearms or knives businesses. We know about that one. Or to take any action allowed under RSA 207:59. So that means you have to go jump to 207:59 to see what that says. 207:59 is another preemption statute, and it's a preemption statute that deals with the authority of the state to basically provide for, taking wildlife and hunting and that sort of thing on properties around the state. But that section includes a very interesting provision in it. It says nothing in this section shall be construed as affecting a political subdivision's property rights concerning land owned and controlled by that entity. So that raises a question right on its face. I mean, it seems to me, and the way we have looked at this in the city, is especially to Senator Gannon's question about use. We've looked at that and said that absolutely gives the city the right as a property owner to prevent the use of a firearm on city property, because most of the time somebody's out there using a firearm for purposes of at least hunting or that sort of thing. But we've also extended that to target practice and that sort of thing. We do not believe that that's unlawful under the current statute, in contravention to some of the folks that have spoken here today. And it raises a question which I have thought about testing, but have not yet, haven't had an opportunity to, with respect to whether or not 207:59 in the language in there allows municipalities, local municipalities to regulate firearms on properties sort of generally. So I just wanted to point that out to the committee. That it's not included in the current language. It's a key omission from the current language. And I think that the intent of the legislature has been pretty clear that, at least with respect to the use of firearms on municipally owned properties, that the municipalities have the right to regulate that. And then finally, I have to tell you, in my personal capacity,
Mr. Mullins, we have reached the 3-minute mark.
thank you. In my personal capacity, I am also opposed to this bill. Thank you very much. If there are any questions, I'd be happy to answer them.
Okay. All right. Are there any questions for Mr. Mullins? Okay, seeing none. Thank you, Mr. Mullins. And I see we have Tom Cronin.
Yes.
Okay, let's put Mr. Cronin through.
Thank you, Senator Carson and members of the committee. My name is Tom Cronin, Director of Government Relations for the University System. Quickly, just with relation to how this bill, we believe, would impact the university system, and if I can speak for my colleagues at the community college system, the current law prohibits political subdivisions, right, from enacting ordinances. The university system, community college system, we are not political subdivisions. So from our perspective, as written, the current law does not apply. On the other hand, the legislature has given both of our systems broad authority via our Board of Trustees to regulate and ensure the safety of our campuses, which is where we believe we get the current authority to regulate firearms as we do on our campuses. Our reading of HB 307, as both outlined in the preamble sections and then throughout, would be to far broaden existing RSA 159.26 in a way that would then include the university system, the community college system, and therefore prohibit our Board of Trustees from having the kind of rules and regulations we currently have in place.
Thank you very much for your testimony, Mr. Cronin. Are there any questions for the committee? Okay, seeing none, thank you very much. Is that it, Margaret?
Yes, I do not see any other hands.
Okay, I am going to go ahead and close the public hearing on House Bill 307. Next, we have House Bill 334, and I'm going to call the prime sponsor, Representative Burt.
Representative Burt, if you could virtually raise your hand. I see Representative Silber with their hand raised.
Okay, why don't we put Representative Silber through? Maybe he's going to be introducing the bill for Representative Burt.
Representative Burt has asked me to introduce the bill because he could not be here today, so he apologizes, and I apologize on his behalf.
Okay, thank you.
334 is a cleanup housekeeping bill that something was just erroneously or inadvertently omitted when constitutional carry was passed in 2017. And what it does, it provides, it's a very, very short bill. I'm sure everyone who comes before you says their bill is really very simple. And everybody thinks their bill is very simple. Believe it or not, this bill is very simple. It looks like there's 14 lines in the bill. And what it does is it extends constitutional carry to off-road vehicles and snowmobiles, which were not included in constitutional carry for some unknown reason. No one knows why, but now this is designed to clean it up. It's very simple. The language changes just in a couple of lines, and it makes clear that if you're entitled under constitutional carry to carry a firearm, you can do it while you're riding on an off-road vehicle or a snowmobile. Very simple. That's it.
Great. Thank you very much for your testimony. Are there any questions for Representative Silber? Senator Gannon.
Thanks for taking my question. You don't think that the reason it was they weren't included is maybe people were afraid they'd flip over and discharge of a weapon, or do you think maybe there was intent when we left off-road vehicles and snowmobiles off?
Thank you for the question, Senator. As a longtime firearms owner,
sure,
and having worked my way through law school in New Orleans carrying a weapon as a private detective, I can tell you that modern firearms these days all have a variety of safety features, and the likelihood of an inadvertent discharge from a rollover is nil.
Okay, that gives me some comfort. Thank you.
Senator French has a question.
Thank you, Madam Chair. Thank you, Representative. This is only for pistols and revolvers, not long guns, correct?
That's correct.
Thank you.
Okay. Are there any further questions for Representative Silber? Okay.
I'm sorry. I'll be brief.
You have another one, Senator Gannon?
Really quick.
Sure.
Just so I understand, because someone asked me, why aren't long guns included?
They could discharge.
Okay. Well, I thought if they're in a holster, I don't know. Okay. Is that the answer, Representative? Okay.
That may be the answer, but I think that long guns, shotguns and rifles are already permitted to be carried on these vehicles.
Okay. Thank you.
Okay. Are there any further questions for Representative Silber? Okay. Seeing none, thank you very much. Next, we're going to Lauren LePage.
Good afternoon. My name is Lauren LePage. I am the state director for the New Hampshire National Rifle Association, state director in New Hampshire. I'll be very brief. This is a common sense, just cleanup bill, as the Representative Silber stated. From the permitless carry law that was passed in 2017. We are fully in support of this legislation, and it would stand to reason that an individual should not be deprived of their right to self-defense simply because they decided to recreate on an ATV or a snowmobile versus in their vehicle when they can already carry. So for those reasons, we are fully supportive of this bill and respectfully request the committee to pass HB 334. Thank you.
Thank you very much, Ms. LePage. Are there any questions for Ms. LePage? Okay, seeing none, thank you. Okay, next we're going to go to Alan Rice.
Good afternoon, Madam Chair, members of the committee. I have submitted written testimony. I will be as brief as I can, and respecting the committee's time. Gun Owners of America, which I represent as the state director, we're strongly in support of Senate Bill 334. And I wanted to take a minute to address the question that Senator Gannon had asked Representative Silber. Senator Gannon, an adult can now carry a handgun on a snowmobile or an ATV, provided they obtain a pistol or revolver license. House Bill 334 eliminates the requirement for a license and would treat a snowmobile or an ATV like a private automobile or even a boat. You can carry a gun on a boat without a license. And that's why I believe the representative said that it brings consistency to our laws. I hope that answers your question. And as I said, I've submitted written testimony out of respect for the committee's time. I will thank you.
Okay, thank you very much, Mr. Rice. Are there any questions from the committee? Senator Gannon?
Yeah, Mr. Rice, thank you. No, my question earlier was, I was concerned. I didn't realize that the safeties, he said there's absolutely no chance of a handgun going off if it was dropped. I'm thinking of ATVs and snowmobiles flipping over. I was concerned there could be a discharge. He assured me that that couldn't happen, so I'm happy.
Okay, are there any further questions? Senator Khan?
Thank you, Madam Chair. Mr. Rice, I think you might be able to answer the other question that was raised. Is there a reason why this is limited to pistols and revolvers?
Yes, Senator, because the constitutional carry law is limited to pistols and revolvers.
Okay, thank you. That makes sense.
Okay, are there any further questions for Mr. Rice? Okay, seeing none. Thank you very much, Mr. Rice. Next, we're going to go to Sadie Zavgren.
Sadie, if you could virtually raise your hand. I do not see Sadie.
Okay, next we'll go to Joe Hannon.
Mr. Hannon, if you can virtually raise your hand. I do not see Mr. Hannon.
Okay, all right, that's all I have who are signed up to speak. I know that there's some folks who have their hands up. Let's go to those folks, Margaret.
All right, I will go to Raymond Belanger.
Hi, everybody. I'm back. I'm for this bill. Although I have a carry permit, and my son, he's got a small ranch of his, and he uses a quad to do work around the ranch, mend fences, kill weeds on the backside of the pasture, and he often carries a sidearm. And some of the farmers and stuff that are around, they've carried them for years on their own land, not worrying about it. But they ventured off, there could be a problem because a neighbor might not like their sidearm. This helps make it so that they don't have to worry about where they're carrying their sidearm when they're working around their ranch, using their quads. I mean, they used to ride horses, now they ride quads. And as far as rifles, I think that, if I'm not mistaken, you could have a rifle on one of these. It can't be loaded so that Fish and Game can see who's hunting illegally or not. They can have it on there. It just has to be unloaded when you're traveling in the woods to keep poaching down. I hope that was helpful. Thanks a lot.
Okay, thank you very much for your testimony, Mr. Belanger. Are there any questions? Okay, seeing none, thank you again. Okay, we have a couple more folks, Margaret.
Yes, next we have Mr. Itzy.
Okay, let's put him through.
Thank you, Madam Chair, members of the committee. For the record, I'm former Representative Dan Itza, and I'm speaking on behalf of New Hampshire Firearms Coalition. Having been a co-sponsor of constitutional carry and co-sponsored similar legislation over the succeeding years, I'm fully in support of House Bill 334 and hope that you'll approve it. Thank you very much.
Okay, thank you very much. Are there any questions for Mr. Itzig? Okay, seeing none, thank you. And we have, who do we have next, Margaret?
We have Representative Silber.
Again?
Yes.
Thank you for calling on me again. I forgot to mention that this bill comes to the Senate from the House on a roll call vote. There is bipartisan 223 to 145. So it was bipartisan vote. Thank you.
Okay, thank you. Anyone else?
We have Zandra Rice Hawkins.
Okay, let's put her through. Good afternoon again, Ms. Rice Hawkins.
Good afternoon. I think you all know my name by now and what I'm here for. So I just want to say we have seen this bill several times in the legislature. There is a risk of accidental discharge to an accident, bumper, spill, and anybody who is in the vicinity is in danger when that happens. And, you know, there have been a lot of improvements for safety mechanisms, but they're not foolproof. And we just in the last couple of years have seen, you know, well-known gun manufacturers like Sig Sauer have to offer fixed parts for, you know, firearms that they had sold that had issues when somebody dropped them and the gun went off. So we do still have those kinds of issues around. And I guess one of the things to also consider is whether or not older firearms, because this legislation does not specify a year after which the firearm would be permitted, if you would have situations of somebody using either one of those ones that had been ill manufactured or that was an older firearm that would have that problem. But more to the point, I just have to say, I just don't get this legislation. Usually I don't even testify against it because it just seems so absurd and out there. I mean, do you really need a loaded firearm when you're snowmobiling? You know, we used to go to my great grandpa's farm. You would get on the snowmobile, dad would pull you and a couple cousins up the hill. He'd drop you at the top, you'd sled down to the bottom. It was a big old farmland, and you'd jump back on the snowmobile, go up to the top of the hill. We'd whip through the woods. Do we need a loaded firearm when we're doing that? It's just so absurd to me that this is even a question. So that's my testimony. Thank you.
Thank you very much, Ms. Rice Hawkins. Are there any questions for Ms. Rice Hawkins? Okay, seeing none, thank you very much. Was that the last person, Margaret?
Yes, it was, Senator.
Okay, terrific. I'm going to go ahead and close the public hearing on House Bill 334. We have 2 hearings scheduled on 2 amendments to House Bill 108. It was suggested that we do have these public hearings. They're both pretty much the same. And from what I understand, because of the software, there was an issue with who could sign up for what amendment to speak. So what we're going to do is I am going to call the people who have signed up to speak, and I'm going to ask them to tell us which amendment that they are supporting and that they are speaking to. That way, our committee secretary will be able to annotate that correctly in our hearings. Is that going to work, Jenny?
I think, Senator, we need to do 1144S first, just because that's how we listed in the calendar, and then go to 1251S. Sorry.
Okay, terrific. All right, so I'm going to open the public hearing on amendment number, what is the number again, Jenny?
1144S.
1144S. Again, this is an amendment to House Bill 108 FN. This amendment has come about because of a recent Supreme Court decision concerning attorney-client privilege. And I am going to let Senator Khan, who is the sponsor of the amendment, speak to his amendment.
Thank you, Madam Chair.
Sorry to interrupt, Senator. So sorry. Sir, 1144S is your amendment, not Senator Khan. Senator Khan's is 1251S.
Because I'm like, because I have an amendment 1250S, which is mine, And then, and I've got Senator Khan's here. Let me see if I can find where it went. I've actually printed it out. I have it downstairs. I'll have to go get it. Okay. Mine, I believe, I'll go first. The amendment is language that I received from the Attorney General, who had worked with some of our commissioners who were very concerned over the decision. And it is very clear. And in my opinion, it's very clean. It speaks to the right to know exemptions. And it says that records protected under the attorney-client privilege or the attorney work product doctrine. So basically what it's doing is exempting those two pieces of work from the right to know law. Okay, so Margaret, let's start putting folks through. Oh, Senator Khan?
I just add, Madam Chair, that the amendment that I would have offered is exactly the one that you have offered. We came up, I get brilliant minds work in the same direction, I guess. So no harm in not considering the one that I proposed. I think yours does the job adequately and leads up to this hearing. So thank you.
Okay. Terrific. Thank you. Okay. Okay, and you and I are both on the second one, so that's pretty good. So I'm just gonna go back here to 114S, and there are a few people who have signed up in support. Okay, can we find out who's in support, Margaret?
So I do have a hand raised, Donna Green.
Okay, let's put through Ms. Green.
Senator, I'm sorry to interrupt. Before we go forward, I think there's some confusion going on. I don't know if we could recess for a couple minutes and just get straight on which amendment we're discussing presently. I think there's some confusion.
Okay, that's fine. We can do that. The committee will be in recess for 10 minutes. Thank you.
Well,
I think we're all squared away.
good.
Sorry, guys, that was my fault. There were so many amendments flying around last week concerning this bill, so, but we've got it figured out and we're ready to move forward, so we'll do it. I think we're just waiting for Senator Khan.
He's hiding.
I don't think he's hiding. He's probably having a coffee break.
Fresh supply.
Right.
Nice.
I wish there were Cubans, Harold, but that would be illegal.
Are they still?
Yes. Unless
I thought that
I
was
don't know.
lifted during the Obama administration.
I don't think so.
Well, I
Thought
don't
we
know.
decriminalized them when we decriminalized marijuana.
No, I don't think so. We haven't done that either yet, Harold. You're still waiting for that one. Well, we decrimmed it, but sort of.
Well, we did do decrim, but you're
Sort
talking about legalization.
Yes.
Two different things.
Rick, can I buy Cuban cigars? I don't think so.
Yeah, if you're in Cuba.
Thank you, Harold, for that pointing that out.
Yeah, but if you go to Western Europe, you can probably get them.
Yes, you can, and you can get them in Canada too. But you're not supposed to bring them back, as far as I know.
You can't import them. I don't know what the law is to possession, but I will say, without offering this as legal to advice to anyone, I have been told that the proper way to destroy contraband is to burn it.
Ah, there you go.
Well, there you go.
That's legal advice for you.
That's not legal advice, I assure you. It may just be a punchline.
It's a good punchline, though.
Okay, are we to the point, Jenny, where we can get going?
I think technically, since we recessed for 10 minutes, we've got about 2 more minutes left.
Okay. Not a problem.
Harold, have you gone to Five Guys Smoke Shop?
Oh yeah.
Oh, you haven't? Of course you have. Okay. I can't afford his stuff. The good ones that are like a lot of money.
Are you have to pay?
Oh yeah. Well, I don't take gifts and bribes. I don't know about other people.
You too. Honest to God, you too.
Yes, I pay for every apple I get. Yep. Just the way I am. I did go to St. A, so.
Okay.
Well, we're almost through. Shouldn't be too much longer.
That's what you said at 3 o'clock, Sharon. Shouldn't be much longer.
That's why I gave you a break.
No, it's my fault.
That next one was gonna be long.
Senator Whitley's with us. She's just listening, eating chocolate cake.
That's okay.
We're 4:37, Senator, if you want to move forward.
How were those cupcakes? by the
Close.
way?
I was eating, but not chocolate.
If you don't have enough for everyone.
I didn't want to be rude. That's right. If I can't share. I didn't want to
Okay.
be rude.
All right, I'm gonna take the committee out of recess. There was some misunderstanding with the amendments, and I apologize to the public. We had a lot of amendments that were flying around here last week on this particular bill, and there was a mix-up. The first amendment, 1144 LS, dealt with the substantive language within House Bill 108 that the committee felt we needed to talk about. And the amendment 1251S was an amendment that was put in with Senator Khan and myself that reflected the language that came from the Attorney General's office as well as from our commissioners. So I will begin by asking if there is any member of the public that would like to testify on Amendment 1144S. Please raise your hand. I see that there's an individual, David Taylor, perhaps?
Yes.
Why don't we go to Mr. Taylor?
Thank you, Chairman Carson. My name is David Taylor and I live in Durham, New Hampshire. I served for 12 years on the Oyster River School Board and at least 20 years on the Long Range Planning Committee, where I still serve. I also have been a member of Right to Know New Hampshire for several years. And as such, I've helped people across the state enforce their right to know. So I'm very familiar with the use of right to know across the state. This amendment effectively adds one sentence to the current language of the bill, and basically says that the list that this bill would require people to create about sealed minutes, that list must be kept in a public place. My experience has been that sealed minutes are properly kept in a locked file cabinet. So if someone were to stick that list in that same locked file cabinet, which obviously only a few people have access to, that would make it more difficult for, say, a clerk that serves the public to go in and just get that list. So, I mean, it's a simple thing, but it would make it easier for people to get access to this list. So I think it's a good idea. I'd also like to say in general that the amendment includes the language of the whole bill, that I really think this is an important bill to put forward. In my 12 years on the Oyster River School Board, we would not very often, but occasionally seal minutes for our non-public sessions. And except for those cases where, for example, it was related to the acquisition of land and there was a very known time frame when those minutes would become unsealed, I don't remember any single instance over those 12 years where we went back and unsealed minutes that had been sealed before, especially from many years before. So I know in general, the practice is once minutes are sealed, except in those cases with the limited time frame, it basically becomes a black hole and they go away. If this list was available, and so you didn't have to trudge through all the records of minutes to figure out whether might be sealed minutes, this list would allow members of the boards to say, look, we need to review these minutes and see if they still need to be sealed. That is a duty. The right to know law specifically says that duty belongs with the public body, and so that public body must have a tool to allow them to do that. For that reason, I would ask you to please support this amendment and this bill. Thank you.
Thank you very much, Mr. Taylor. Are there any questions for Mr. Taylor from the committee? Okay, seeing none, thank you.
Thank you.
Are there any other folks who would like to speak to Amendment 1144S?
I do not see any other hands.
Okay, I will close the hearing on Amendment 1144S. And I'm going to open the hearing on Amendment 1251S. And since Senator Khan, you are the first named person, would you just like to introduce the amendment?
Certainly, Madam Chair. And exactly as you had pointed out, this amendment originates because of a recent Supreme Court decision and the concerns of municipalities and other governing bodies in the state that they continue to have the same privilege as any private citizen would have to allow as privileged attorney-client discussions and products produced as a result of those discussions. So I believe there'll be people speaking from those vantage points, and think that they can probably explain their positions better than I can. But thank you, Madam Chair, for allowing me to introduce this and for your co-sponsorship of this amendment.
Thank you very much, Senator. Are there any questions for Senator Khan from the committee? Senator Gannon.
Real quick, because you probably know the area better than I do, Senator, but aren't you afraid we're going to lose information? Aren't people going to be able to hide behind the attorney-client? I appreciate it when it's you, a person yourself, but when you're acting in a position, I don't know, school board, superintendent, something, don't you really lose shouldn't you lose that client privilege? Because you're acting in not your personal privilege, but you're acting in a different role or capacity than personally.
Right. And so you're questioning the public's right to know. And
Yeah, I'm
that,
thinking they have more of a right to know, but I'll listen to everyone's testimony. Thank you.
I think that's where I would turn as well. Thank you.
Thank you.
Okay. Are there any further questions? Okay, seeing none, I'm going to call Matthew Broadhead.
Hi, good afternoon. This is Matthew Broadhead. Can you hear me?
Yes, we can.
Thank you, Madam Chair. So my name is Matthew Broadhead. As you said, I'm the Senior Assistant Attorney General. I'm a Bureau Chief at the Transportation and Construction Bureau. In that capacity, I represent all divisions within the Department of Safety and the Department of Transportation, as well as the Division of Public Works at the Administrative Services. Attorney General John Famella has asked me to testify today on behalf of the entire DOJ and our support behind this amendment. If I could just kind of explain what the attorney-client privilege is and what the work product doctrine is, just for your edification. The attorney-client privilege, the kind of the classic view of it is any person seeking legal advice from a lawyer is subject to this attorney-client privilege. It's permanently protected from disclosure when they're when they're engaged in a communication seeking legal advice. That protection is owned by the client, not the attorney. And so it's for the benefit of the client who's trying to seek legal advice. The work product doctrine is any material that's created in anticipation of litigation or during litigation and might have legal strategies or theories that are the mental process of either the client or the attorney. The privilege exists for the benefit of or for the purpose of enabling a safe space for people to seek legal advice. It encourages the free flow of truthful information. If you don't have that privilege, clients may not seek advice, or if they seek advice, they'd be less likely to tell the truth about what it is that they're facing. And so the whole point and purpose of the privilege is to allow that unguarded and unvarnished view of what the issue is and how the attorney can help the client. As Senator Khan had said, there was a Supreme Court case. So for decades of the right to know law, the privilege has existed, which it's a privilege based in common law, and statutes are not presumed to amend common law. And we disagreed with the Supreme Court's decision last week or 2 weeks ago now on April 20th. It upended that long line of cases where the privilege has been held to be in a per se exempt from RSA 91A, and instead held that it could be that 98(1)A has waived the attorney-client privilege, subjected it to a balancing test. So that means that it raises the possibility that even over the objection of a client, that the record could be disclosed subject to a balancing test. So the effects of this cannot be overstated. This is one of the most closely guarded and cornerstone privileges of the American legal system, this attorney-client privilege. So, and attorneys have an ethical obligation under Rule 1.6 to not turn over any records that relate to representation without the client's informed consent. And so this does create a complex set of legal and ethical issues and problems for government attorneys. Just so that you know, the Department of Justice represents 100 state agencies, licensing boards, commissions, elected and appointed officials in the government, the executive branch. And many of them rely on the DOJ for near constant legal advice. And under RSA 99D, we represent state employees not only in their official capacity, but in their individual capacity when they are sued in government. We also provide advice and counsel to all these state agencies, as well as criminal investigations. So what the court has done is open the door to set an uneven playing field for state employees. imagine in a criminal prosecution, the attorney and investigating officer are exchanging information about either legal theories of investigation or maybe even as they are investigating criminal acts. Those can all be discoverable in by a criminal defendant in litigation when they would have been shielded from discovery under the normal rules of discovery. That has a huge monumental consequence in the Attorney General's ability to enforce the criminal laws of our state, as well as civil litigation. When Rule 502 protects in civil litigation protects from discovery confidential client information or attorney-client privileged information. Well, now litigants will be able to circumvent the rules of discovery and seek information that from the state, where the state cannot seek the same information with respect to the private litigant. We're a sounding board at the Department of Justice. Our mission is to ensure that our state agencies comply with the law, that we're putting forth good policy, and agencies in that vein, it come to us with many different ideas, and some of which need to be thoroughly vetted from a legal perspective. We should continue to encourage our state agencies to come forward to provide unvarnished truth to the Department of Justice so that we can best serve them to implement policies in accordance with the legislature's directives. So that's all I had. I'm happy to take questions. Thank you, Madam Chair.
Thank you, Mr. Broadhead. Senator Whitley has a question, then Senator Gannon.
Thank you, Madam Chair, and thank you, Attorney Broadhead, for taking my question. So you testified that you believe that exposing these types of communications under 91A could lead to fewer communications between public bodies and their attorneys. Can you take that a step further? What would result from those fewer conversations, and what would be the impact on the taxpayers? What could this mean for litigation with public bodies and against public bodies?
Sure. I think in the agency advice because we provide three functions at the Attorney General's office. We provide counsel on issues of compliance. We represent employees in connection with litigation, and we enforce the criminal laws through prosecution. So I think it would have an impact on all three. One is that there'd be less likely for a client to pick up the phone and to call or to send an email and request advice. And I think in terms of cost or impact, if it's more difficult to defend a client in court because, for instance, our legal strategy in a case is now being disclosed to the opponents, well, we don't have their legal strategy, and therefore we're at a disadvantage. So it could cause more cases to be settled if our litigation strategy is known in advance. It makes it more difficult. Like I said, the cost wouldn't just be measured in dollars and cents. The cost would be to the protection of the community in criminal cases. So I think you can measure it in a lot of different ways. I'm not sure if I answered your question, Senator, but that's generally my response.
You did. Thank you.
Senator Gannon.
Thank you, Madam Chair. Real quick questions, probably just directed to me. I'm fine with privilege. I'm weak on work product. What were you saying about work product?
Sure. Work product is that actually applies to documents as opposed to communications. So the attorney-client privilege is mostly communications, back and forth. The work product doctrine is a qualified privilege that says that any document that's generated in connection with potential litigation, such as, say, a risk assessment or a draft pleading, that's all work product. And so it governs the document itself.
Thank you.
Okay, are there any further questions for Mr. Broadhead? Okay, Seeing none. Thank you, Mr. Broadhead. Next, we are going to go to Thomas Mullins.
Hi, good afternoon again, members of the committee. Madam Chair, Tom Mullins, I'm the city attorney in Keene. And I'm in-house counsel for the city. You probably realize that there are municipalities that have both in-house and use private law firms for that purpose. Most of the cities have, or larger cities have, in-house counsel. What Attorney Broadhead said that applies to the Department of Justice with respect to this issue applies equally to the city, only in a smaller version of that. My office provides the same kind of advice internally to the management staff and to the folks that run the city. From my perspective, it really is an abrogation of the attorney-client privilege and the work product, and will make it very difficult to be able to communicate with the staff here, the city manager, city council, et cetera. I think it's important to understand that it also places council in a very tenuous position because we operate under our rules of professional conduct, and my license is dependent upon those rules, as are the licenses of all of the other municipal council in the state. And those rules basically, as was pointed out, prohibit me as counsel for the city from violating either the confidentiality provision or the provision with respect to work product. And if I violate those rules, then I'm putting myself at risk, as well as putting the city at risk in doing that. So that as a practical matter, my testimony for the committee is to tell you what it's like from the ground on that. Now, as a practical matter, it's going to be very difficult for me in my office, because we do this with the over 130 or 40 right to know requests that we get every year, many of which include requests for information out of my office. It's going to be very difficult for me to reach into my own work product and decide whether it meets the balancing test or not. I mean, in most instances under the balancing test, it's very difficult for the government to claim a privacy interest. If there is no privacy interest, then you don't even get into the test. It all has to be released. So for me to be able to do that, from my perspective, to Senator Whitley's question, I'm going to have to retain outside legal counsel, because I don't want to be in a position of having to try and decide whether my opinion with respect to the balancing test is accurate or not. But the problem with that is, once I retain outside legal counsel to do this, outside legal counsel has the same problem that I have, because they are now representing the city with respect to this question under the right to know law. So outside legal counsel is going to be hesitant to put themselves into that position as well. Before, it was a very clear, bright line test. Before the Hampstead decision, which, by the way, the court decided in just a couple of pages and in a footnote, decided to essentially abrogate the attorney-client privilege. Once they did that and put it into this balancing test, I can no longer take a right to know request that I get from the local newspaper, requesting all of the information out of my office, and simply say no, right? I now have to go through the balancing test, or I have to get outside legal counsel to go through the balancing test to make that determination. That is clearly going to increase the cost to local communities. As to Senator Gannon's point, I'd like to point out another practical reality to this. We are very transparent, as transparent as we can possibly be in the city, despite some of the issues that you hear otherwise. We bend over backwards to try and do this. But our representatives are elected to represent the people here in the city of Keene. Well, the people in the city of Keene are oftentimes engaged in litigation through their representatives. An example of that right now is the opioid litigation. The city of Keene is engaged in that. And we are trying to recover substantial sums from the defendants in that case to help reimburse the city and the state, frankly, for all of the costs associated with dealing with the opioid crisis. Under this particular incarnation now from the Supreme Court, all of that litigation is potentially at risk to being disclosed to the public and to the defendants. And that is certainly going to hamper our ability to deal with things like that. So not wanting to take too much of the committee's time, I have to say that I'm is a representative of the city, a city attorney, absolutely in favor of this amendment. And I know that, quite frankly, this decision just set off a hand grenade within the municipal bar because it puts all of us at risk for that. And quite frankly, we have to decide at some point, do we keep our license or do we get dinged by the court for a right to know violation? Thank you very much. Happy to answer any questions.
Thank you for your testimony, Mr. Mullins. Are there any questions from the committee? Okay, seeing none, thank you. Next, we're going to go to Jim Kennedy.
Hello, Honorable Chair, members of the committee. My name is Jim Kennedy. I'm the city attorney for the city of Concord, New Hampshire. By way of background, I'm a former assistant attorney general and was also on the governor's commission for the right to know law back in 2008, and have written several treatises on the right to know law. And in my capacity as a city attorney for more than 10 years for Concord, like my colleagues, Mr. Broadhead and Mr. Mullins, I work with issues related to the right to know law on a day-to-day basis. And in all my practice as a government lawyer for more than 20 years now, the attorney-client privilege has been safeguarded and utilized by my office in a responsible manner to safeguard the functions of government. I mean, that's what the attorney-client privilege does, is it ensures that government officials are acting in accordance with state law or applicable law on a day-to-day basis. We help them, we allow them to ask questions. It allows them to probe what a government can and can't do. It helps to avoid procedural errors that may be statutory or rule-based. It helps them avoid more substantive errors that could be costly to a municipality. And it allows them to ask these questions in confidence. Now, I certainly support all the questions or all the statements offered by Mr. Broadhead and Mr. Mullins, and I don't want to go into repeating all of that. I certainly have all the clients that they have. I represent the city manager, the incomplete administration of the city of Concord, the city council, and all the boards and commissions, and maintain attorney-client privilege with each of those persons and/or entities. But it's also very important to know that the attorney-client privilege is not absolute. And so the attorney-client privilege can be challenged. And it's not a tool that can be used to hide or protect bad actors. And so there are exceptions to the attorney-client privilege that are very important to know. And these have been exceptions well understood in New Hampshire. The attorney-client privilege cannot be used to engage in any type of fraud or crime. And so these protections are absolute. And so to the extent that there's any type of nefarious or bad conduct going on relative to a public official, the attorney-client privilege cannot be used to protect that conduct. And there are also, and that's set forth in just by way of information in New Hampshire Rules of Evidence 502, that us the attorneys all subscribe to and are bound by. The same is for the work product doctrine. You can look at Superior Court Rule 21, and you can see that there are exceptions to what may be required to be produced under work product. These are the rules that bind attorneys' conducts relative to the attorney-client privilege and work product. We encourage you to support this amendment to the right to know law. We think that is a very important amendment. It's very important for the operation of government. It's very important, as Mr. Broadhead stated earlier, not to give private actors the upper hand in litigation or other matters confronting government. I've represented a number of different agencies in the state involving a number of different issues. Some very complex litigation involving tax issues, the First Amendment, real estate issues, property issues. It's certainly not going to benefit government if I have to turn my file over at the beginning of litigation to the other side. I urge this committee to support this bill and to make it a part of the right to know law. I'm open for any questions.
Thank you very much, Mr. Kennedy. Senator Whitley has a question.
Thank you, Madam Chair, and thank you, Attorney Kennedy, for your testimony today. So because you have this longstanding experience with the right to know law, I'm curious whether you can speak to sort of the court's decision and whether it really comported with the plain language of the actual statute.
Well, I certainly respect our Supreme Court and the decisions that it issues. By way of further information for this committee, the city of Concord led an effort with a number of other cities, including the city of Manchester, the city of Nashua, the city of Dover, the city of Rochester, the city of Portsmouth, and the city of Keene, in filing an amicus brief regarding the Hampstead decision, outlining our position that the court came to the wrong conclusion by looking at the four corners of the right to know law. And certainly, motions for reconsideration are authorized actions, and that's what, presumably parties are authorized to do. And we did that in accordance with Rule 30 of the New Hampshire Supreme Court rules for such action. I will also say that the attorney-client privilege is recognized in New Hampshire's right to know law. So RSA 91A2, which sets up and defines what a meeting is under New Hampshire's right to know law, excludes communications or consultation with legal counsel as a meeting. So a public body can have a discussion, consultation with its legal counsel, and that consultation or discussion is not subject to any of the meeting requirements under the right to know law. So that's the meeting side of the right to know law. This amendment that you are looking at under 91A5 addresses the record portion of the right to know law. And so we would like to see this amendment made abundantly clear that attorney-client privilege information and attorney work product is protected from disclosure under New Hampshire's right to know law.
Thank you.
Okay, are there any further questions for Mr. Kennedy? Seeing none, thank you very much, Mr. Kennedy. Next, we are going to call Margaret Burns.
Good afternoon, Madam Chair and members of the committee. Again, I am Margaret Burns, Executive Director for the New Hampshire Municipal Association, and we are here in support of this amendment to House Bill 108. I will not repeat the excellent points that have been made by the individuals who have come before me, Matt Broadhead from the Attorney General's office, Jim Kennedy, Tom Mullins. Those are the same reasons for which we are in support of this bill. Attorney Mullins referenced it as a hand grenade going off in the municipal bar, and I think that is an excellent explanation. It was a similar effect felt across the 234 cities and towns of New Hampshire that the Municipal Association represents. Since the court's decision in the case that has been described to you here this afternoon was issued, this has become a priority issue for NHMA, our members, and the community of attorneys representing the municipal and governmental clients in the state. So we urge the committee to support 108, to support the amendment to 108. If you have any questions, I'm happy to take them. But as I said, I will not repeat all the points made here this afternoon.
Thank you very much for your testimony, Ms. Burns. Senator Whitley has a question.
Thank you, Madam Chair. I do appreciate, I know everyone is getting tired, but I just want to ask a similar question to one I had asked before, and something that Senator Khan had raised about this idea about balancing the public interest. So Attorney Byrnes, I'm curious about your thoughts about, if this fix isn't achieved, what is the cost to taxpayers in the long run if our public bodies, and our public bodies include, our select boards, our school boards, largely made up of volunteers. So what is the impact to taxpayers in the long run if they, don't feel comfortable communicating with their attorney? Could it result in increased costs from litigation, uninformed decisions? Those are the long-term costs I'm interested in hearing about.
both of the examples that you have given are the long-term costs of this. If the decision is allowed to stand as is, it will be devastating both for state and local government. In the first instance, it creates simply a chilling effect on the communication between governmental entities and their attorneys. And that chilling effect will simply lead to governmental clients, municipalities, local governments, counties, the state, questioning or being more cautious than they should be in simply reaching out to get legal advice and to receive written legal advice, which is normal course for state and local entities to ensure that they are complying with the law, to get advice before they act, to get advice before they enact ordinances, spend money. The list goes on and on, what municipalities and state government will need for legal advice in order to operate under the law. And now what we will do is create an environment where local officials will question or be overly cautious in wanting to reach out and get written legal advice because they have to be concerned about whether under this subjective balancing test down the road, the legal advice that they have received will be made public. And it really just destroys the integrity of the attorney-client relationship and really the core of what the attorney-client relationship is and how it should apply to government entities in the same way that it applies to private clients. But yes, the cost is also another serious concern. And I think Attorney Mullins referenced one potential consequence with the cost, which would be if municipalities need to now consider engaging outside counsel to assist them in reviewing their own legal advice for disclosure under the right to know law and to conduct that subjective balancing test. That's an entirely new cost that towns and cities would have to bear in complying with this new standard that has been created under the case that came out a couple weeks ago. So there is both the financial cost as well as, I think, the cost to our local officials being able to make good and well-informed decisions, which includes being able to receive legal advice.
Thank you.
Are there any further questions for Ms. Burns? Okay, seeing none. Thank you, Ms. Burns. Next, we're going to Carolyn McCarley.
Carolyn, if you could virtually raise your hand. I do not see Carolyn.
Okay, next we're going to go to Donna Green.
Hello, Madam Chairman and honorable senators of the Judiciary Committee. Handwork grenades might be going off in municipalities, but citizens are lighting fireworks. And your body, who represents the citizens, must be reminded that you do not represent governmental entities. I'm Donna Green. I'm here to testify against the amendment. And I have a long history with the SAU 55. So I'm here representing the School District Governance Association of New Hampshire. And that's an organization that empowers elected school district officials to reclaim control over budgets and curricula. The amendment is a direct response to the Supreme Court case of Hampstead School District versus SAU 55. And as you know, this ruling imposes a balancing test between the public interest, those who paid the bill for the legal advice, and the privacy interests of the administration of the public body, those who spent the money. This seems eminently fair and reasonable, and a gift of renewed transparency to the public by the wisdom of our highest court. The public who pays for the legal services has a right to know the product unless there is some compelling reason to withhold it from the public. As it happens, I'm also a former school board member of the Timberlane Regional School Board, which was part of SAU 55. I left office shortly before the activity mentioned in the suit. When I was a Timberlane School Board member and part of SAU 55's board, I learned about a lawsuit between a parent and my district through an article in the newspaper. By long-standing and reprehensible practice, the board was never informed of special education disputes. The superintendent of SAU 55 claimed that he held the client attorney privilege and would sometimes refuse to provide the board with written legal opinions when it did not serve his purpose. The same superintendent would pursue legal action without a board vote simply because he had the money in the legal line of his budget. In fact, he engaged me all the way to the New Hampshire Supreme Court in a right-to-know dispute that SAU 55 ultimately lost and cost the taxpayers $50,000 without a vote of the board. Now, this is a superintendent you might think who is without proper supervision, but with my experience, I have come to learn that nothing he did was by his own invention. Elected officials are very often kept in the dark about legal consultations and advice, even when it is paid for by their own constituents. This is why it is imperative that legal advice be subject to disclosure with reasonable protection for things that truly do need privacy. For administrators who are used to being able to hide a great deal from public view behind the cloak of legal consultation and the lawyer-client privilege, this ruling is a disaster. For the public, who has been footing millions of dollars in legal fees for advice that is sometimes in favor of the administration rather than the public's interest, this is a cause for rejoicing. There is an inevitable divergence of interest between those that pay the bills and those that hire the lawyers in public bodies. A school board, for instance, will retain the services of a lawyer, and the lawyer will look out for the well-being of the board as a whole. All the while, the public is paying the bill for advice that may work against the public interest. Let me share one more story from my own experience. In 2014, my district received a very substantial return of surplus from the LGC Health Trust. This was unanticipated revenue, and by law, the receipt of this money required a public hearing. The superintendent and my own board disputed the need for this public hearing, but in light of my protests, obtained a legal opinion on the matter. This legal opinion was shared with a few members of the school board, but was withheld from me despite my demands to see it. Weeks later, this letter was read at a special meeting called specifically to address my calls for a public hearing. The legal opinion completely supported my position, but the chairman and the superintendent misconstrued it to be otherwise. I was censured at that meeting for eroding the integrity and credibility of the district, and so on and so forth. All this could have been avoided had the legal opinion paid for by my constituents been provided to me and the public when it had been received, instead of being used as a piece of political theater. As for the need to hire an outside lawyer to do the balancing test, I would ask very respectfully that attorney why the public body itself couldn't do the balancing test. In fact, I don't understand why the public body itself isn't even vetting the right to know requests in the first place and referring it to the attorney. The right to know law is very, very clear and easy to understand. As far as litigation strategy being disclosed, why, there is a balancing test. And as for, the client attorney privilege being a safeguard to the functions of government, I would respectfully say that the only safeguard to the function of government that citizens have is transparency. And the Supreme Court gave it to us, and I would urge you not to countermand their wisdom. Thank you.
Thank you very much for your testimony, Ms. Green. Are there any questions from the committee? Okay, seeing none. Thank you. Next, we're going to go to Chris Bolt.
Thank you, Madam Chairman, members of the committee. My name is Chris Bolt. I'm a partner of the law firm Donahue, Tucker, Chindella. And I'm not here, though, on behalf of any one client or group of clients. I'm here as a practicing lawyer of over 33 years to give you my perspective in support of your amendment to House Bill 108 so that 91A:5 is amended to clearly retain the exemption of documents that are subject to the attorney-client privilege and the attorney work product privilege. I also bring you my perspective as being elected as a selectman in the past, having served as a planning board member, library trustee, and in each role having used at some point in time advice of outside counsel. Our law firm dates back to 1985. Over that time, we have served literally tens of thousands of clients, both on the private and the public side of life. Private individuals, businesses, groups of abutters, developers, nonprofit organizations, a myriad of public bodies, including approximately currently a third of the municipalities across our state, several school districts, village districts, and even acted as special counsel to some counties and agencies. Our 16 lawyers will currently work on approximately 900 billing matters this month. If you were to exercise this case and subject our files to the examination of 91A going back to 1985, that would be an ungodly expense to our municipal clients. Not only that, it's an immense amount of time that would be needed to dig those files out from storage. This is not something that in my wildest dreams I would ever have thought would even be a requirement prior to April 20th with the Hempstead decision. This is frankly an attack on a fundamental right of a client, and that client happens to be the town, city, whatever organization, body it is. That's a bedrock foundation right in our American system of law that goes back, frankly, to the times of the ancient Romans, if not before. As Attorney Kennedy noted, our rule of professional conduct 1.6 starts off with a clear and express prohibition. A lawyer shall not reveal information relating to the representation of a client. Then it goes on to unless those items that were specifically called out by Attorney Kennedy. I firmly believe that I took one oath of office as a lawyer, standing in front of the Supreme Court that day, as Senator Gannon, Senator Whitley did in their day. That office, oath of office, included we are bound to protect the confidentiality of each client, their rights and their interest. I do not have two classes of clients, one to whom the attorney-client privilege and attorney work product privileges apply, and one to whom it does not. I ask that the committee recommend passage of the amendment so that it is clearly stated that the effects of the Hempstead decision is not the way, the law of our land in the state. This is similar to what the general court did in response to the Supreme Court's decision in Effingham, McDonald v. Effingham, where you then amended 91A:3, Roman 2, subsection, to add subsection L, so that attorney-client communications could be discussed in non-public session without the attorney present on the phone or in the room. This is not something that I take lightly. It is something, however, to answer Senator Gannon's question on hiding information, that's not the type of information that is covered by the attorney-client privilege or even the work product privilege. If a client is sending me a document, that document itself may well be subject to production. The fact that it is sent to me, the questions my client asks, my answers back to the client, that is what's protected by the attorney-client privilege. My file, on the other hand, is what is I deem normally protected by the attorney work product privilege. So that's the distinction. If the document is in the town's records already, that document may well have to be produced. Just because it comes to me does not put it under the Maxwell Smart cone of silence in any way. This, frankly, as Attorney Kennedy and Attorney Mullins indicated, might well become a full employment act for attorneys to have to review all of those records for the balancing test. And with all due respect to Ms. Green, she has had some interesting experiences. Her experiences and frankly, the experiences that underlie this case support that old adage of bad facts make bad law. And we ask that you solve this problem by adding the provision as proposed in Amendment 1251S. I'm happy to take any questions you have. And thank you very much, by the way, for your longevity on this meeting and the fact that we could attend by Zoom.
Thank you very much for your testimony. Are there any questions for from the committee? Okay, seeing none, thank you very much, Mr. Bolt. And next we will hear from Lori Ortolano.
Good afternoon. Can you hear me?
Sure can.
Okay. Thank you very much for giving me this opportunity to speak to the honorable members here. My name is Lori Ortolano. I'm a resident of Nashua. I was a former school board member in Litchfield for 5 years and on the budget committee for almost 3 years. And I am not in favor of this amendment 1251 to HB 108. I think allowing a balance test to exist for this information is the right thing to do. I appreciated Attorney Kennedy's comments regarding this matter, saying that there are already provisions in the law that allow bad actors to be called out, namely through the crime fraud exception, Rule 502 and SC Rule 21. But I think it is too limited. And I know down here in Nashua, I've been addressing and investigating an assessing office issue for about 2.5 years. And I think we've got some bad actors, and it's really hard to call them out when it comes to right to know and disclosure. Our legal office has taken over right to know requests, and the mere request to find out the number of right to knows submitted to either get a list or just get the right to know submitted by a citizen to the legal office is not disclosed because it's protected under attorney-client privilege. Now, in this case, when a citizen of Nashua writes a request into the legal department, I'm not certain who the client is. It's just a citizen making a request. And the response that comes back should be available for any citizen to know what questions have been raised by the public. And that is not permitted to be reviewed here in Nashua or provided to any citizen who wants to know what requests have been submitted. You simply can't get that information. When it comes to meetings that are being done, when I was on the school board in Litchfield, we were pretty good. We had, I think, 2 pretty progressive superintendents that unsealed public minutes right away. We would go into non-public, unsealed non-public minutes. We would go into non-public session. We'd take an action, let's say on hiring. We'd receive advice. When we came out of non-public session, we would put on the record the motion of the board, the hiring, or a teacher's contract, or anything that had come to a decision would come out immediately and go on the record so the public could be informed. In Nashua, that type of process is not being used. Our Board of Assessors had 20 meetings remote last year. They voted on roughly 15 settlement and appeal agreements with properties, mostly commercial, that had filed lawsuits. Once those agreements are settled and the board signs off, they're public record, but they never release that information into public circulation through the minutes or unsealing the minutes because they don't believe in it. And any type of work that's done on those settlements is not publicly available. You're playing a guessing game when you're a citizen to write a right to know to obtain these settlements. You have to submit them monthly and see if anyone will come back and tell you what's been settled. It's a ridiculous game. I think this balance test is appropriate and proper for citizens to be able to have access and challenge some of the things that are going on. I do think, as I said, Nashua has a lot of bad actors right now. playing the game. And when it comes to right to know, it's extraordinarily challenging down here. So I certainly want to see change, and I'd like to see the language in the bill stay as it is. Thank you.
Thank you very much for your testimony this afternoon. Are there any questions for Ms. Ortolano? Okay, seeing none, thank you very much. Margaret, that is everyone that I have who was signed up. Are there folks in the waiting room?
We do have 3 hands raised: David Taylor, Jordan Eulery, and Right to Know New Hampshire.
Okay, why don't we go to Representative Eulery?
Thank you, Madam Chair. I apologize for not being here when you called the bell. My schedule had it for 2 o'clock, but you know, it is what it is. At any rate, the amendment that's offered, excuse me, my wife will get that in a second. There we go. Tries to create a balance. A little bit about myself. I've worked for attorneys for many years doing investigations. The work-client product and the attorney-client privilege is very important when you're doing investigations. It provides a degree of protection and anonymity, and allows you to get the information needed for the case for your client. At the same time, when you're dealing with a city or town, some of that information is by nature public. I think the amendment attempts to secure the attorney-client privilege. I'm a member of the Hudson Planning Board. Madam Chair, you're aware of what's happening down here, and you're aware of what happened just Wednesday night. I fully expect a subpoena any day of the week now. In that, we were engaged in attorney-client discussions to explain what happened, or what will happen, or possibly could happen regarding that activity. That was private. I don't see anything wrong with any public board putting in their minutes that they went into private session for the purpose to discuss something. At the same time, I want to maintain attorney-client privilege. I believe that with the plethora of attorneys on this committee, some balance can be reached. And I'm hoping to be able to provide any assistance that may be possible. Thank you, Madam Chair, for the late testimony. If there are any questions, I would be happy to answer them.
Thank you very much, Representative. Are there any questions for Representative Eulery? Okay, seeing none. Thank you, Representative. Who's next?
David Taylor. Oh,
okay. There was someone else. Did you say from Right to Know New Hampshire?
yes.
Why don't we put them in, because Mr. Taylor has already spoken to us once before.
Okay.
Hello, this is David Sad from Right to Know New Hampshire. Can you hear me?
Yes, we can.
Thank you very much, Madam Chair. I ask you to oppose this amendment. The first point that I would like to make is that there were a number of previous people mentioning that the advice of attorney-client privilege, but we often, I think, make the wrong assumption on who the client is. I mean, the client ultimately is the citizens. They're the ones that pay for the legal advice, and they're the ones that either benefit from or suffer from that advice that's given. So I think that's an important point to make. Another attorney mentioned that attorney-client privilege is not absolute. However, this amendment is looking to do just that in terms of making attorney-client communications and records a per se exemption. And they point to the fact that the Supreme Court ruling that came out is reversing years of activity in the area of attorney-client privilege. However, I hope that you do read the Supreme Court ruling because it says in there, and I quote, the contention that records protected by the attorney-client privilege or the work product doctrine are per se exempt from disclosure under the right to know law rests upon an understandable but mistaken interpretation of our precedent. So the Supreme Court is coming out and they're clarifying the fact that it's never been a per se exemption. For years, the attorneys have been going on the premise that it's a per se exemption. And now, because there's clarification given, they're coming back and saying, oh, well, we were going on the assumption it was a per se exemption, so now let's make it a per se exemption. So I ask you to not do so by opposing this amendment. The other point I would like to make is the three-part balancing test that is used is a common balancing test for a number of other records that are also, in some cases, withheld from the public. It's a good way, I think, to allow the public to gain access when disclosing that information will provide a greater benefit to the public than non-disclosure in protecting the government's interest in such non-disclosure. After all, how does a citizen measure the actions of public officials that take action based upon legal advice if we're never allowed to see the legal advice given? We don't have a way to evaluate the actions of our public officials. Oftentimes they hide behind the fact that, on advice of counsel, we've done in such and such, and we thus don't have a way to see what was that legal advice. So I think the Supreme Court ruling got it right. And all they did was clarify what was the case all along, which is it's not a per se exemption. A balancing test is required. And so I ask you to oppose this amendment. Thank you very much, and I will take any questions.
Thank you very much, Mr. Sad. Are there any questions for Mr. Sad? Okay, seeing none, let's go to Mr. Taylor. Is there's someone else to know? Who is that person, the other person who has their hand raised?
Jordan Eulery.
Okay, well, they both testified twice. Let's go to Mr. Taylor.
Thank you, Senator Carson. This is my first time testifying on this amendment. I testified earlier on 1144, so I won't go through my introduction again. I find that this amendment will be unnecessary. Contrary to much of the testimony you've heard, this is not eliminating either the attorney-client privilege or the work product doctrine. This is just subjecting it to a balancing test as opposed to the assumed per se exemption. And I think it's important to realize that every member of the bar, of the court, all the judges were practicing attorneys. They've used the attorney-client privilege and the work product doctrine in their day-to-day practice. They understand its necessity. They understand the importance of it. And I agree with all the comments saying how important it is. And what that will do is that when they go into that balancing test, they will make good judgments on what documents should be disclosed because they are exceptional cases. And I believe that the Hampstead case looks like an exceptional case. Twice the Supreme Court quoted the lower court ruling, pointing out that the chairman of the board made a public statement characterizing the report that was given to them. What the question that raises to me is, was that characterization disingenuous? Did it mischaracterize the report, and that opened up a greater public interest? Because that was certainly a major factor that they weighed into it. I would also point out, not only are the judges attorneys who are very familiar with the value of these privileges, but if you look at the history of cases, and I submitted written testimony and I've listed all of the cases dealing with attorney privileges of some sort, except for the Ettinger case. Unfortunately, earlier Attorney Bolt referred to that as the Effingham case. It's actually the Ettinger case. Except for that Ettinger case, and perhaps in this Hampstead case, all of the other cases have allowed various documents withheld for attorney-related privileges to be withheld from disclosure. So clearly that shows that the courts over the years, since 1975, have valued these protections. In fact, the first case in 1975, the court put in a protection for a meeting with a consultation with legal counsel before the law even had that provision that it was referred to earlier. So they clearly appreciate the importance of protecting this right. And I believe that in the balancing test, when it's applied, all of these horror stories that you've been hearing about won't really come to pass. Lastly, I would like to point out that, if you look at the jurisprudence from the Supreme Court over the last several years, they have been moving away from per se exemptions. And I believe that the clear understanding of that, if you go back to the case of Associated Press versus the state in 2005, and I'll quote them, they said one of the reasons that they said that a particular statute was unconstitutional was because it, quote, does not permit the court to make the individualized determinations required by the state constitution. That is, that they were saying that effectively a per se exemption on these records may be a violation of the state constitution because we have, Part 1, Article 8 that says, we essentially have a constitutional right to know. So, even if you attempt to put in this per se exemption, you may not be able to overcome that requirement in the Constitution. So, for those various reasons, I don't think the balancing test is going to cause all of the horror stories that you've heard. And frankly, I believe this per se exemption would be ruled unconstitutional in the end. I hope that you will oppose this amendment. Thank you.
Thank you very much for your testimony, Mr. Taylor. Are there any questions for Mr. Taylor? Okay, seeing none, thank you.
Thank you.
And Margaret, let's go to Representative Ulrich.
It looks like he took his hand down. Representative Euler, if you could virtually raise your hand.
Okay, let's go to Representative Ulrich, our last speaker.
No, thank you, Madam Chair. I took my hand down because I took my hand down and I screwed up. So you guys do what you want to do with this, but it's some sort of test in order to perhaps defining what you mean by, or what anyone means by, attorney-client privilege has to be done with an attorney for a pending case. And that needs to be identified to the public, that there is some discussion going on, not just blind. Now we're not going to talk about it because. I would also say that perhaps an ombudsman would alleviate a lot of the problems that you heard about tonight. But we'll see how that goes. Thank you, Madam Chair. If you have any questions, give me a call.
Okay, thank you very much, Representative. Okay, Margaret, is there anyone else?
We do not have any other hands.
Okay, I am going to close the public hearing on Amendment 1251S. Okay, we are done for the day. Thank you all for hanging in there. Can I get a motion to adjourn our meeting for today? Senator Gannon moves to adjourn. Is there a second? Seconded by Senator Whitley. I will call the roll. Senator Whitley?
Yes.
Senator Gannon?
Yes.
Senator Khan?
Yes.
And Senator Carson, yes. Thank you all for hanging in there this afternoon. It was a long afternoon. We've got another long afternoon tomorrow, but at the conclusion of tomorrow, we will have heard every bill that we've had.
Wow.
So we're right on schedule, and we're just going to keep moving. We've got to get our work done. But many thanks to Margaret and to Jenny for hanging in there with us today, and we will see you all tomorrow. Take care.